petitioner, Lordship, as per the last order, Lordship, it was to appear today. And Lordship had specifically also indicated, however, today
not possible to take up your matter today. It is there in the list. It will not be taken up. Take it up after the vacation.
Lordship,
I understand, but it's not so urgent that it cannot wait. They have to bring that instructions.
I suppose they would have the
Yes.
instructions.
What?
Another direction.
Notification right now.
Bring it on the reopening date. On the reopening date, it will be there in the list.
May I have your...
I understand. Take it up.
Milord, I mentioned this matter on the last occasion on Monday, Milord. Milord, today the date given in the presentation from Milord, the matter is not appearing, Milord. It's a group 5 matter, Milord.
Group 5 today it will not appear.
There is some
You ought to have been aware group 5 is taken up only on Tuesdays. What is this harm urgency, sir?
Not the urgency is that the petitioners before your lordship are members of primary cooperative societies, my lord, whose elections have not been conducted for more than 3 to 4 years, my lord. And as a result of that,
after vacation. After vacation. Yes, it will appear in the list after vacation. No urgency. Yes. No snap order can't be granted in these matters. After the vacation will be taken up. What is it so hurry? No, sorry, sir.
Lordship, I have mentioned twice before your lordship when your lordship was pleased to grant my prayer for any distinct matter, group 5 matter. Matter was released by court number 14 on 7th May.
It's a motion.
Yes, my lord.
Motion. Give it a handover after the vacation.
My lord, kindly.
After the vacation will appear. Yes,
May I
ma'am.
have your lordship's kind leave to, I'm mentioning 3 matters. I have for withdrawal, your lordship.
Yes,
Because
handover.
Ceci will...
Handover. Now, madam.
Yes, I will hand over.
Yes, call the list.
Daily list item number 1.
My lord.
I beg
My
to
lord, may I, my lord?
My lord,
May I be allowed, my lord?
if your lordship kindly come, have a perusal of the last order passed by.
My lord, I was to mention, my lord.
Yes, Mr. Churaria.
My
Yes.
lord, on Monday, my lord,
Yes.
Monday, if your lordship remembers, my lord, a matter was to come on today's list, my lord.
Which matter?
My lord, Shiv Rice Mill, my lord, on Monday, I extensively, my lord, thereafter your lordship said that it will coming within 50 and thereafter you said it will coming as to be mentioned as in the list for Wednesday.
No.
Shiv Rice Mill, my lord.
এটা নিয়ে নাও তো কি বলছে ওনার কাছ থেকে I'll check up Mr. Churari. I'll check up.
My lord. Grateful, lordship. Grateful.
Yes.
My lord, your lordship kindly
Wait.
perusal of the last order.
Respondents have produced. Yes. Yes, sir.
Lord, Mr. Mojumdar has to.
If it is for you,
Milord,
both. I'll send it there.
Milord, I am ready. I'm agreeable.
You ready?
Yes, I'm agreeable.
Mr. Munjundar, it is ready. Are you ready with this?
Test which was made by the Central Forensic Laboratory. Let them produce the...
They have already produced it.
I'm carrying.
No, they have already produced it. I've seen that on the last occasion. You were there. OMR sheets are there. Today, both of you were to take instructions whether this can be sent.
Yes, Milord. My client is.
Have you got instructions from your client?
No, my lord.
No instructions.
No.
Very well. It will appear on monthly list. Same position to be mentioned. Take instructions from your client. Now it will be done by the Central Forensic Laboratory.
We are agreeable.
Take instructions from your client, Mr. Wood. Next.
It will appear in June, Milord.
Same to be mentioned. He has to take instructions. He does not know whether his client will know. So without him taking instructions from his client, how can he agree?
Milord, not only this, I'm instructed.
I am not going to pass an order of court in this matter for this specific reason. If his client understands is no use proceeding further, he will not. But if he considers that it is better to proceed, he will proceed. I give him the option.
Mila,
Come back with instructions.
every matter we are agreeable. Like this. I have the instruction that we will be agreeable.
Very well. Come back on the next Monday. Reopening
After the
reopening date. What is the difficulty, Mr. Pro? Yes, item number 2.
Item number 3.
3, yes.
Item number 3.
Tuta ki hoyeche, tuta ki hoyeche?
Item number 3, I am appearing on behalf of the petitioner, my lord, virtually.
Supplementary discussion. Because of supplementary. Yes, item number 3, who's appearing?
My lord, I am appearing on behalf of the petitioner. Your lordship had disposed of this, my lord. Why it is appearing as to be mentioned, my lord?
There is a reason.
My lord.
What were you challenging here, sir?
Lord, challenging the decision, my lord, if your lordship sees the order passed by the appellate forum,
Yes.
as that was disposed of on the ground, they have no jurisdiction or power under the act to condone the delay. Now, because of the special circumstances which prevented the writ petitioner from taking out the appeal within time and for approaching the authorities for redemption within time, citing that we have preferred the writ petition because, my lord, they could not extend the time.
Yes, you were to take instructions, Mr. Banerjee. I have already passed on this. You were not there, perhaps. I have passed this order and I said that I will not sign it because I have directed. You have seen that order? No, it's not signed by me. I dictated in open court. I'll just indicate to you. Today, Mr. Banerjee, learned advocate, appearing in support of the writ petition, would however submit that the petitioner is interested to comply with the order dated 12th December 2023, whereby the additional commissioner granted opportunity to writ petitioner to redeem 24-carat gold bar of foreign origin upon payment of rupees 8,21,729, along with appropriate interest and redemption fine of rupees such and such. I find from the statements made in the writ petition that the petitioner is a resident of Manipur and at the relevant point of time, by reasons of the law and order situation prevailing in the state of Manipur, claims to have taken refuge in a relative's house to protect herself from violence. This has led to the delay in filing the appeal before the Commissioner of Customs Appeal, Kolkata, which came to be rejected on the ground of limitation on such and such. However, since the petitioner now is only interested in redemption of the seized goods by allowing an opportunity to redeem the seized goods upon payment of duty, interest, fine and penalty imposed by an order dated such and such, and taking note of the special circumstances faced by the petitioner, and in the peculiar facts of this case, I permit the petitioner to avail the benefit of the order dated such and such, passed by the Additional Commissioner of Customs, subject to the petitioner complying with the provisions therein within a period of 30 days from date.
Yes, sir.
Correct? No difficulty?
No.
Yes, sir.
My lord, fine with me.
Yeah, this is the last. Since the petitioner would contend that the petitioner has paid 7.5% of a duty payable as pre-deposit while maintaining the appeal, the concerned authorities are directed to inquire into the matter, and if the duty is found to have been deposited, to give the benefit thereof. All parties stand. Yes, this is the order.
Yes, as per the
Well,
addition order dated 12th December 2023.
Yes.
As per
Yes.
the,
Yes, ma'am.
Actually,
yes, ma'am.
very well.
Lordship may kindly direct the authority because since there
No, you had some confusion. That is the reason why I had kept it under the heading to be mentioned
no, my lord, it is
with regard to the extension part.
Extension part, there is no
I'm
issue.
extending the time.
There is no issue. There is no issue.
Very well.
Only with regard to the adjudication order, that compliances have to be done. And in what manner they
I'm not setting aside anything. I'm just permitting it because the appeal court did not entertain the appeal. So the order is sustained.
Yes, Malad. Only with regard to the compliance of the adjudication order,
Yes.
Malad, let there be a
I permit the petitioner to avail the benefit of the order dated 12 December 2023 passed by the 2023 passed by the Additional Commissioner of Customs subject to the petitioner complying with the provisions therein. Provisions therein.
everything is there.
So within 30 days from date. From date.
From there.
So that's from 19th. I'll sign it today. It will be uploaded.
No issue.
Very good.
Call the next matter. Hello.
Sir, I'm for the respondent. I'm paying for Passover. Mr.
No
Banerjee.
Passover, sir.
Mr. Banerjee is in court number 1.
No Passover. Where is Mr. Singh? Yes. Where is Mr. Singh? Who is for the petitioner? Yes.
Well, I am for the petitioner.
No, you understand what is the purport of the order, what I have allowed. So I have retained it for you to take instructions because you challenge, your contention was that the pre-deposit was only limited to payment of penalty, duty, and not the penalty, correct? But I have allowed you by recording your submission that payment of duty, penalty, and fine, everything you will pay, whatever is there. Yes, I have recorded since I have not decided that. No, I will not hear you afresh on this. এই এটা হয়ে গেছে তো নাও ফাইলটা নাও হ্যাঁ ওটা হয়ে গেছে ফাইলটা তো অর্ডারটা এখানে আছে একসঙ্গে দেবো এটার সঙ্গে ওটা আছে দাও এই পরের ফাইলটা দাও ইয়েস $190 yes একটা কাস্টমস অ্যাক্ট দাও বের করে এইখানে আছে দেখো কাস্টমস অ্যাক্ট আছে কাস্টমস অ্যাক্ট ছোট ছোট বই আছে ইয়েস পেজ 196 ইয়েস correct you are the appellant number 1 yes correct others have not come forward where is the cost title of the appeal ঠিক আছে গো ঠিক আছে
হ্যাঁ বুঝতে
কার নাম দিয়েছে দেওয়া আছে নাম দেওয়া আছে already।
This has been already appropriated in a different case.
Actually, yes, my lord.
Yes, 195, that is the finding.
That's why, my lord, in this case, my lord, we pay pre-deposit. But on what?
No, the pre-deposit you wanted adjustment and come to 195.
Yes, my lord. I have checked, my lord. They have, my lord, committed some mistake, my lord. That's why, my lord, now we want to pay the pre-deposit.
Entire amount. You pay the entire amount along with fine. Otherwise, I'll know.
My lord,
That is over. That previous order is already adjusted.
my lord, that is separate appeal, my lord. That is separate appeal altogether, my lord. This is separate because there are two so-called notices, two order in originals, my lord. And it is one of the two, my lord. Because others appeals are pending before the tribunal, my lord. But those orders are passed by the commissioner in other so-called notice, my lord.
Yes, language of 129E is very clear. Come to 129E. You want, I'll give an interpretation of that here and now.
My lord, under subsection 128, my lord,
Come to 129E, place it.
129, my lord.
Yes. He cannot control, the authority passing the order cannot control your pre-deposit in an appeal.
Oh, my lord.
He has no power. It is for the appellate authority. If he writes something, that order will be bad to that extent.
My lord, kindly come to 129.
Yes. Now, sir, you had made the submission that you wanted to pay.
Yes, my lord. But
If you ready and willing, say I'll recall the order.
then, my lord, my humble prayer, my lord, candidate in accordance with law, my lord. Pre-deposit I shall pay in accordance with law, my lord.
What I got? This is the only issue. Challenging the appellate order you have come. What pre-deposit? Either you agree or you don't agree.
I am paying, I will pay pre-deposit in accordance with law.
No, I will, sir, I will not leave things to the consideration of the authority once again. He has decided it.
My lord, kindly
What do you want?
my lord.
What do you want? The High Court will be represented there as if High Court cannot decide a matter. He will say that I have decided a matter. High Court, you have challenged before the High Court. High Court again has sent it back to me.
My lord,
What is
no,
this?
my lord.
No,
The
sir.
pre-deposit amount, my lord, I shall
No,
pay.
sorry, sir.
Kindly, sir, my lord, kindly from 129.
Yes, yes, yes. If you are not ready and willing for this, I will recall the order.
I shall pay, my lord. The tribunal, my lord, 129.
Yes, the tribunal or the commissioner, as the case may be, shall not entertain the appeal under subsection 1 of 128 unless the appellant has deposited 7% of the duty in case.
My lord, duty.
Wait, duty.
My lord, where?
Where are you getting a comma?
My lord, after
Where is the comma? There is no comma after the duty. There is no comma after the duty.
duty for common.
Half percent of the duty in case where duty or duty and penalty are in dispute, or penalty where the penalty is in dispute.
My lord,
Again, read it, sir.
my lord, duty, there is a comma, my lord.
Upon subsection 1, read it.
My lord, under subsection 1 of section 128,
Comma.
comma, unless the appellant has deposited 7.5% of the duty, comma.
There is no comma.
My lord,
There is no comma.
comma, my lord.
In this book, there is no comma.
My lord.
There is no comma.
My lord can consider this book.
I am holding a universal. You can show me. I will not go by this, sir.
This whether duty or duty and penalty dispute.
There is no comma here. Anyway, if I take it except for comma also, if I accept a comma also, if I accept a comma for the sake of argument also, in case of 7.5% of duty.
Duty, my lord.
So it is qualified by where.
Where?
So in case where duty or duty and penalty are in dispute.
My lord, where duty is disputed, 7.5% of the duty, or where duty and penalty is disputed, 7.5% of the duty, my lord. There is no, my lord, 7.5% duty and penalty. 7.5% of the duty, comma. My lord, circular also clarifies this, my lord.
I'll place it after the vacation. Unless you see, unless I am convinced, I'm not going to pass any order. Because you are saying that one particular book has, you bring in the notification in that case.
My lord, this is also, my lord, an explanatory notification about pre-deposit. My lord, may I place once? 6. Paragraph 6, my lord.
Very well. I'll not go through it today. Learned advocate representing the petitioner. Although the order was passed, although an order was passed on 19th May 2025, however, since the learned advocate representing the petitioner wanted to take instructions, the matter has been placed under the heading to be mentioned. Today, after hearing the arguments advanced by the learned advocate for the petitioner, I am of the view the matter may require reconsideration. I am of the view that the matter may require reconsideration. Having regard thereto, the unsigned order dated 19 May 2025 is recalled. Full stop. Place this matter under the heading motion in the monthly list of motion in the monthly list of June.
Motion.
Same position. I'll again take it up. No difficulty, sir. And you bring the original notification. Stop. The petitioner is directed to place the relevant notification notifying the provisions of the Customs Act. Is an amended provision. Amended provision.
129 is, my lord, letter.
Notifying the amended provision. Petitioner is directed to place before the parties are directed to place before this court the relevant amended provision of section 129E of the Customs Act 1962. Relevant notification notifying the provisions of section 129E of the Customs Act 1972. If the comma is removed,
Then
if the comma is removed as is in my book, then 7.5% of the duty and penalty. And you see what was the unamended provision. Unamended provision required you to put in duty and penalty also.
At that point of time, my lord.
Sir, this clarification, if it is contrary to the statute, will not do, sir. I want to see if the comma is not there, then it relates to duty as also duty and penalty. Yes, next. Because in this universal copy, this comma is not there.
But 4 in this matter, I am applying. Union of India. That is 4.
Union of
Yes, all right. Yes.
ঠিক আছে চলো চলো পরে দিতে করবো।
one second.
Yes, madam.
I am appealing for the
Yes, encashed. Where is the original title deed?
It is my declaration from instruction from the bank, your lordship.
Yes, what affidavits you have or what assets you have?
My lord, regarding the petitioner, my lord, there was I annexed my lord bank account and he earns rupees 16,700 per month as a advocate enrolled in the year 2021. And as per mother of the petitioner, the video of the loan taken loan.
You get back the title deed, mortgage this, and repay the loan. Finished. This title deed you
Yes,
get
your
back.
lordship, it is also bank's proposal.
You cannot get it, sir. This will be no distress mortgage. You have to give it back to them. I'll give it back to them.
No, your lordship, now we are returning and then fresh loan will be given in the name of.
You want it? It can be done that way.
He is the junior member 2000.
But he has to, I understand, madam. I understand. That is the reason why I am ensuring that he gets back his property for which the loan has been returned. But he has to return this amount.
My lord,
The bank will reprocess this
Yes.
if you want.
entire amount.
Correct, cleared. You get back.
Another-
He can't run away. Please understand. He's an advocate. He cannot run away. He cannot hide somewhere. He has to practice. Please understand the situation. So he has to repay. He might get the time. The bank will reschedule the loan.
Already, my lord, representation has been made before the authority that they intend to surrender the flat, my lord, regarding another. My lord, let them consider.
Very well. You give back that particular affidavit of assets.
Let them consider. My lord, I already.
There is a difficulty, your lordship.
Representation.
Affidavits of asset. Affidavits of an affidavit of assets. How many affidavits you have filed, madam?
My lord, two is regarding mother and regarding petitioner.
Only Vishwanath. Two matters are there.
One matter. Because my lord, I want.
Two several affidavits of asset filed on behalf of the petitioner concerning the petitioner and the mother of the petitioner, wife of late Rajesh, mother of the petitioner, namely Manushi Chatterjee, wife of late Rajesh Chatterjee, filed in court today, are taken on record that a copy of the aforesaid affidavit of asset be made over to the London advocate representing the respondent bank. Full stop. Mr. Mishro, learned advocate, appearing on behalf of the bank, has placed before this court a certificate issued by the Shatragachi Cooperative Bank Limited, dated 21st May 2025, and would submit that the bank has already received the payment. Now, they would submit that the check made over by the petitioner to the bank in full and satisfaction of the loan amount of the outstanding loan amount concerning the loan account number 225521740286
Yes, your
has already been encashed.
encashed.
Mr. Mishra has brought the original title deed
I'm handing over this.
which was mortgaged by the petitioner's father, petitioner's father,
Petitioner's father.
to avail the aforesaid loan, full stop, since the loan account has been closed upon receiving full and final settlement. Since the loan account has already been closed upon receipt of the entire amount advanced along with interest, let the copy of the original title deed pertaining to the aforesaid loan account be made over to Ms. Dhawal, learned advocate representing the petitioner. Petitioner is also there. Be made over to the petitioner who is personally present in court. The petitioner shall issue a receipt formal receipt acknowledging receipt of the aforesaid document. Full stop. Insofar as the yes, ask him how can you pay? How much is there? 7 lakhs.
8 lakhs. Please come to page number 13, Your Lordship.
I will do this. Ask him, Miss Dhawal, ask him if he can pay 2.5 lakhs for the time being. I will send it. I'll give him time. Then I will send it to the mediation center.
Bank is ready to waive off.
I understand.
Everything
Yes,
bank
yes,
is ready
yes.
to cooperate.
Ask him if he can pay.
Under the entire amount.
I understand.
The bank
As if he can arrange 2.5 lakhs is not a big amount so far as the flat is concerned. I will place this matter in the monthly list of.
No.
My lord, that is
Ask him to arrange it in June. I'll pass an order in June. Once he pays 2.5 lakhs, I'll send the matter to mediation. But this amount has to come. Ask him. He'll have some time. Yes. Insofar as not. Full stop. Insofar as the loan account number blank, the petitioner is directed to deposit a sum of rupees 2,50,000. I'll give him time. I'll give him time. 2,50,000. 2,50,000 to the bank. On or before the matter is taken up next. List this matter in the monthly list of July.
The difficulty, what happened?
Madam, impress upon your client in a distress cell. He will not get this money out. On the contrary, if he sells the flat, if he wants to sell the flat, get a buyer for his flat, the other flat, I will ask the bank to surrender the deed here, and I will ensure that this takes
Your
place to
Lordship,
the
he
court.
cannot sell. Why, Your Lordship? If Your Lordship kindly come to the affidavit in opposition, page
Yes.
number 24. After mortgaging the property in the bank, what the petitioner has done, deceased borrower has done, he has given the property to a private party and take 7,50,000. It has been clearly written here.
that is the
See, people is in difficulty. He's in distress. You have to understand the situation. You want your money. You don't want
Yes, I
anything
don't
else from
have any
him.
problem if he return the money. I don't-
Therefore, I will give him some time. He might arrange it. He's a professional. He can earn it out.
Yes, bank is also
there is no
ready to
difficulty.
cooperate with him. We don't have any problem.
Madam, he's a professional. He can earn this money. Yes.
enough time, my lord, I will try.
Next. And in the meantime, don't there is an order of
No.
injunction already there.
Your Lordship, please do not pass
Hey,
it.
dekhi. Yes. The interim order has expired.
Yes, Your Lordship.
When has expired?
20. Today.
Okay. The interim order initially passed on, having regard to the direction passed herein, the interim order initially passed on 6 March. 6 March? 6 March? I'll pretend this file matter here. I will ensure you get the money. So what more do you want? 6 March? 6 March, madam? 6 March 2025.
6th March order.
And the 6 March 2025, which was subsequently extended and is valid till today, stands extended, which was subsequently extended and was valid till 19th of May 2025 is reimposed and shall continue till the end of August 2025 or until further order, whichever is earlier.
If he fails, then
I will direct him that he will. You want the money ultimately. First, you get the out of it. What is the principal amount?
the prince
7 lakh.
7 lakhs.
Hmm.
So it principal will come down to 5. Now it is NPA. There is no interest now.
Hmm.
It is now NPA. There cannot be any interest today. So I'll get it. If he can pay up this amount very well, he's a professional. Find out. You only want your money, sir. What do you want?
We only interested in money.
Where's there? That's it. Madam, ask him to put in the money by the honor before the matter is taken up next. So ensure that it comes in end of June. Yes, call the next matter. Yes, where is Mr. Singh? Yes.
Directed by your lordship, the affidavit of assets and affidavit of law undertaking.
Your client is here in court? Very well. Since this gentleman is, you identify him?
Yes, my lord.
Then I'll permit him to go and surrender.
Thank you, lordship.
No, warrant of arrest is there. I'll permit him to go and surrender.
He shall, my lord.
Yes,
He
he.
shall comply with all the order passed.
And where is his undertaking that he will pay?
Yes, yes, my lord.
Undertaking.
Yes.
By when?
My lord, within 10th of June, my lord, I shall pay 10 lakhs, my lord. And
10th of June you shall pay.
within 3 months, my lord, entire amount shall be paid up.
10th of June you will pay 10 lakhs.
10th of
10th of June you will pay 10 lakhs. Very well. And the rest?
within 3 months.
Tell me, where have you said so?
My lord, may I have said.
Where have you said so? Which paragraph?
Yes.
So, Mr. Shannal, you see, your one notice from you has ensured they are present in court. What were you doing? You should have to take proactive steps in the matter, not sit.
Absolutely, Your Lordship. There has been
For 6 years you had been sitting.
fault. There has been fault.
One notice from you ensured their presence in court.
There has been fault on our part, Your Lordship. No doubt.
Then you have to be aware of your powers, how to enforce it.
Not paragraph 8, your lordship, and this affidavit of undertaking.
Mr. Singh, learned advocate, appears on behalf of the Yes, call the list.
Item number 7.
Let us see if you can see at the end of the day, some light at the end of the tunnel. Yes. Yes, Mr. Manager.
But as per your lordship's last order, kindly see.
Yes. What are you challenging? You challenging? What are you challenging?
Order.
Yes.
April 2020.
Which page?
Page 648. Second one.
This is order you and originally you're challenging. In what ground?
I have paid the amount to the defaulter credit. Instead of thereafter the government insolvency and because the insolvency they filed a claim. Because GSTR not filed. In that basis, I have taken the ITC section 16(2). But everything is correct. There was no problem from outside. Problem arose that is GSTR 3 years not filed, which is that amount has been deposited. He is keeping the amount, he has given a declaration to the authorities. And thereafter, madam, they may someone made insolvency. RP was appointed. They filed a claim of the same amount, which has been adjudicated.
The person, you have purchased certain products. Let me understand.
Yes. I have purchased certain product. I have paid the tax to the person concerned. Yes, now I am saying because of the reason he has not paid the amount. Admitted he has paid the amount. GSTR 1 was filed. Showing my amount is paid to him, to the defaulting credit. But he has not deposited the amount for the GSTR for 2 years ago. Now,
Does the statement in 2B show this credit? Does the statement in 2B show this credit?
yes, sir.
Show me that.
GSTR.
No. You are not filing this. Correct? This will be reflected in 2B. Scheme of the act is that once the transaction is there and he files it, his return, it will be reflected in 2B for you to take benefit or not to take benefit thereof. And thereafter you will file your return under 39.
October 24. Certainly 18 to 20.
18 to 20, this mechanism was not there. Not there. Let me find out from the act itself.
1820, this mechanism was not there.
What was there? No, wait, sir. Wait. Your senior advocate is representing you. Why are you making submissions now? No, you will assist him very well, but you should not mix up. Let me find out. Let us come to section 39.
Yes.
No, 37 is furnishing of details of outward supplies.
Yes, that is there.
No, that you will not submit. That is, he will submit. So he has furnished the details of outward supplies, Mr. Banerjee. Once he furnishes this, your 2B will reflect this automatically. You have no hand there. It will be reflected in your 2B automatically. Correct? Show me from the 2B that it is reflected there.
Also can come to place 649. That has not been dealt with.
Yes.
649. The order itself.
But you have an alternative remedy. Why will I inquire into all this?
The reason is manifest error on the part of the statutory authority. My lord,
2 point,
my lord, very simple
2
thing.
point, 2 point.
2.2.
Very well. Let me find out. I see. Here I've got it. Now here it was automatically reflected in 2B.
Yes.
Admitted. It says 2A. It will be 2B actually. Or 2A. Correct. 2A.
2B was not there.
At that time, 2B was not there.
So it was reflected in 2A. Fair enough.
Hmm.
Now once it is reflected in 2A, now he has to file the return under section 39.
Hmm.
Now you have taken benefit of this.
Yes.
And filed 39.
Yes.
And he has taken over the defaulting company.
That is different thing altogether.
No, that is a different issue.
Different
Let us
of that.
understand one by one, stage by stage.
Yes,
Mr. Menon.
yes.
So therefore, up to the stage of his taking credit under 16.4, there is no difficulty. He has taken credit of the amount.
Yes.
ITC taken credit. Now, while filing the return, that particular person did not make payment. Or he did not file the return.
Return. GSTR 3.
Payment was already there. Tax was already deposited.
And he has admitted.
Because he has already, 2A is already there. He did not file the 3B.
3B.
Yes.
And that is why they filed their claim before the RP.
You filed a claim before the RP.
Ah, that is
Filed it.
Yes.
Then how can you recover it from them?
Yes, Karthik is the company, insolvency company.
Then how can you recover it from them? Let me understand this. How can you recover it from them, Mr. Banerjee? Both, you can't enrich yourself, unjust enrichment. Either you say that I could not recover from him. You have made a claim. He is in liquidation. Liquidation or what has happened?
He has taken over the
CRP. And he has purchased it.
He has purchased.
Are we are clean shot, clean slate.
All
Everything is gone. CRP.
clean slate.
Take
There
instruction.
is no allegation of collusion also.
No,
No. CRP is clear. This
Yes.
the language.
Lordship,
Now Supreme Court has made it very
Just
clear.
come up after vacation. Let me take
Yes.
limited. Now, before vacation, we do not want to go into.
Challenging. I should note it what I have heard. Otherwise, I will
Yes,
forget.
Malad, definitely.
Difficulty is I do not remember.
Well,
I
that's
don't
what
have such a memory as you have.
Also, we are little less.
Challenging the order dated
So that matter. 2A was always there. From
Always.
1st January 22, they brought in 2B.
1st January 22.
22. They brought in 2B. So they
So
just,
prior there to there was no auto population
there
was not.
was. There's a difference between 2A and 2B. 2A is dynamic. It keeps changing every day. 2B is static. On 13th, it will freeze.
What is recorded in that other judgment? I have recorded.
Lordships.
That is uploaded. You must have seen that.
Yes, Lordships. Hudusali, that 75-12-1. Your Lordship has taken out the issue of 37, 39.
Whatever you indicated.
Lordships, that is the law. In fact, now, Lordship, because of that judgment, we are being eligible to claim 2 years amnesty scheme under 122A. Because amnesty scheme provided if there is any order under 75-12 is there, I cannot claim waiver of interest. But if it's a show cause, your Lordship are treated as a show cause under 73. Now, once it's a show cause, I can take that amnesty scheme for 2 years. We have applied, in fact. And 1 year, 2021, we have given our report.
So 2022, this issue of this 2B was introduced.
1st January 22. And now, 1st January 22, they stated.
So that is 2A is dynamic.
Dynamic.
So it keeps up changing. The moment you pay, it will change. So it's a
2A is based on 1. It is not based on payment. 1 is not based on payment. 3B is payment. 1 anybody can file. But you pay the tax when you file 3B. Unless you pay file 3B, government does not run tax.
Scheme is this. 3B is filing always. The scheme is you acknowledge the payment made by the other side.
Lordships.
So those are the dates. 13th, thereafter the 20th.
Yes,
on 20th, you will file 3B.
Yes.
So you get the time to calculate and then pay.
Yes, Lordship. That is the scheme.
So you know where you stand.
Lordships. What is my
So
net
you acknowledge that you have received it.
Lordships.
So his liability goes. Now it is shifted onto the other person by filing that 2A.
Lordships. That is how it goes. But what government has done from 1st January 22, it has now become more of 26 AS.
Once you file that 2A, then the person who has transacted is practically absolved of the liability.
But the issue is if the supplier who has shown in 1, it comes in by 2B or 2A. But if he does not file 3B, now government comes and tell me he has not paid tax, you cannot take credit. So that fight is going on. That wires of 16(2)(c) is pending before your Lordships also on that account. In fact, Guwahati High Court Division Bench has read down 16(2)(c). They say unless you provide for collusion, you cannot ask for recovery. That 16(2)(c), in fact, Lordship, my matter of Asian hotels, same issues are pending for Lordship.
Come after the vacation, come up with some of the hearing matters. I want to hear them also. It will be easier.
It will give a clear gamut of the entire scheme of the
yes. Because there are some loopholes here and there.
It is.
Which you are taking and trying to take advantage.
No, not advantage, really.
Yes. No, auto-populated. Yes, auto-populated. 2B is auto-populated. 2B, you get to know where you stand. Yes.
That is no.
No.
This matter is regarding the Rule 9610 omission from 8th of October 2024. Any demand order passed under that rule after the omission, your Lordship has already stated the proceeding in Glen Industries. I have handed over the copy last day, Lordship. And your Lordship judgment same. Now the Uttaranchal Division Bench has passed final orders. Also relying on the judgment of Supreme Court in Kolhapur Cane Sugar, wherein they say omission of a rule from the statute will not be saved under Section 6 of the General Clause Act because it is a rule. It is not an act. This exactly the same matter was taken up by your Lordships in Glen Industries, Lordship, which I have handed over the judgment also. In the
present, I have decided this year.
Lordship, here you have given interim stay because
naturally they wanted to file opposition.
Lordship, that is why. Uttaranchal High Court, in fact, has given the final order on the same line.
Same line,
exactly same line. Kolhapur Cane Sugar is referred and the entire demand order has been quashed.
What is the challenge here?
Lordship, the show cause notice is dated 25th of July 24 at page 100. The challenge is to Lordship recovery of the refund which the government has already granted me on exports.
Yes.
Lordship, I file my reply at page 123 on 29th October 24, and in the meantime, on 8th of October 24, the rule 9610 came to be omitted from the statute book. And the department passes the demand order, Lordships, at page
No,
133.
this is show cause under the provision.
74. 74, they have invoked suppression.
Very well.
They have invoked suppression.
Then,
Lordship, they passed a demand order at page 133 on 4th of February 2025.
Which page?
Page 133, 133.
On
4th of February 2025.
Yes.
In the meantime, Rule 9610, which was the basis of the entire demand, came to be omitted.
How do I get it? That Rule
Lordship,
96
I will.
of the demand.
Lordship.
Where which paragraph?
Lordship, the discussion and finding starts at page 159.
No, from the show cause I can't get it.
Lordship, show cause also. Show cause starts at page 100, Lordships.
Yes, yes. Today the division bench, today Wednesday you have difficulty. But Thursday I have given the appellate side. Thursday also you have difficulty.
Now division bench is taking every day first half.
Oh, then can't help it.
But we have to adjust.
We are
Yes, yes, very well.
Lordship, they kindly take the show cause notice at page number 100. The first paragraph will make it clear. May I please, Lordship?
Yes.
Where it appears that Messrs. This and this address this, having GST and dealing in taxable supply of goods under HS and this, have contravened provisions of section 54 of the CGST Act and WBGST Act, read with Rule 9610 of the CGST rule and the WBGST rule in and have committed offence as enumerated under section 74 inasmuch as they have taken erroneous IGST refund to the tune of rupees this on account of export of goods with payment of duty in violation of section 54, read with Rule 96, read with notification 48, 40 and 41. This is the entire Rule 9610 itself. Lordship, Rule 9610 provided that if I purchase anything and I take benefit of advance authorization, then I cannot export with payment of duty. I should have exported under LUT only. That is what the scheme of Rule 9610 was. But it was highly debated scheme, Lordships. Therefore, in fact, Kerala High Court read down Rule 9610 as unconstitutional. The ultra virus was decided. So thereafter, the council decided to omit this rule from the statute book itself through from 8th of October 24. White notification 20/24, Lordships.
Madam,
In plain matters, the department.
this is a covered matter, madam.
My lord, we are aware of this matter.
Unless you challenge that previous order. No. Unless they challenge the previous order, I am bound by this order. I cannot change my views also.
My lord, in the plain matter.
Unless someone says and you have invite me to become more wiser than that. This is an interim order after all. It's so.
In the plain matter, department was given opportunity to file affidavits, my lord. We may be given opportunity to file affidavits, my lord.
Very well. Challenging the show cause ওটাকে অতদিন না বলে না 6 weeks না বলে না or 2 weeks after summer break,
My lord.
1 week after the 1 week thereafter, liberty to mention. You mentioned in July 96, I'll decide this.
Great.
Already the interim order is there by
Lordships has given a detailed order in.
so it is there.
Macho.
And together.
2024, the GST show cause notice issued under inform number DRC 01, wherein he asked me to file a reply and asked me to appear for personal hearing on 22nd of November 2024. On 21st of November, I have filed an application for adjournment and asked me to give the personal hearing on the subsequent dates. And he passed the order in the month of January 2025, manner. Neither he has given me to give the personal hearing, nor he has asked me to file a further to the to the to reply to the show cause notice. And he has passed the adjudication order.
Have you filed reply?
I filed a reply. Asked me to kindly see page 45 of my writ petition.
Where is the show cause?
Was 29 one. 29 to 43, my lord.
Yes. Where is your reply?
On page 45, my lord. 44 and page 45 is my.
Opportunity of hearing was given.
No, my lord.
No, no. This is not sustainable. Page 51, if your lordship kindly sees. Adjudication order.
Not given.
Not given.
He sought for in his reply.
Lordship kindly sees page 51, 51.
Yes.
Fourth line from the top. Date of personal hearing was fixed on 22nd November. And your lordship got that. Fourth line from the top. The reasoning portion. Date of personal hearing was fixed on 22nd November. On 21st November, only a prayer for 20 days extension was sought to submit a reply. None appeared on 22nd November. Neither any reply had been furnished till date. Point of providing reasonable opportunities of hearing. Failed to. The order is passed ex parte. Well, this is not sustainable.
No, on 21st, adjournment was there.
Adjournment was
Page
there.
45.
He says that he sought for 20 days time.
And asked
But on
for
Where is
on
that?
day,
He filed a reply.
he sought for 20 days time. That is not a reply. That is seeking 20 days time.
Where?
page 45.
Page 45.
44
Which
and
I
page
cannot read, which he can read. Page 45. He sought for 20 days time. He should have taken
and asked for the personal hearing also.
consideration this 20 days time.
Subsequently, they have initiated one recovery proceeding also, my lord. They have built from the credit ledger. They have
The order passed under section 73. all consequential steps taken by the respondents, including initiation of recovery proceedings, stand quashed.
জিনিস করলে আমি এটা করতে দিতাম না, আটকে দিতাম।
4 weeks. Proper officer, 4 weeks.
Yes, my lord. I am ready to file reply, my lord.
4 weeks. I think, ma'am, you don't file it, it's gone.
Yes, kindly.
I have provided for peremptory.
Kindly record, my lord, that no unnecessary adjournment charge.
4 weeks. Peremptory direction.
Yes.
If they seek unnecessary adjournment, we'll pass expert.
Only one opportunity will be given to him.
Today we file the reply.
You can't get everything.
No,
I have given 10 days. You don't file reply, he'll pass an expertise order.
I will ensure, my lord. Thank you.
Great.
My lord,
Yes, yes.
challenging the appellate order, we submitted the petition before your lordship.
Yes, sir. Continue.
My lord, actually, there was an unintended excess availment of ITC in the month of March 2019, and that we have duly reversed following the provisions in December 2019. So we have whatever our admitted excess ITC that we have reversed in December within 6
Challenging
months.
the appellate order dated रिमांडेड ठीक आगे वही आगे हाँ ठीक आगे फार्मर इक्विप which are available on the portal. Yes, next.
My lord. My lord. In this case, actually the fact is excess OA bill was generated. Thereafter, we have excess EOA bills were generated. Some
Excess.
EXEW.
Yes, why?
My lord, maybe the transporter is generating, maybe
No, no.
we are
There is
generating.
an appellate order, my lord, this has to be decided on appellate.
My lord, I am
There is an
129 3 order was passed.
No, there is an adjudication order, my lord, with regard to all different aspects. Your lordship kindly comes to page 45. Not only 129.3.
He is challenging the adjudication order.
No. Appellate order.
Appellate order confirms the adjudication order. Now he has come up before your lordship. This has to be decided on affidavit.
My lord, I am submitting before your lordship one point. What are the issues in the SCN that is confirmed in the order under section 74 and that is confirmed in the appellate order?
Challenging the order passed by the appellate authority and the demand raised in form APL 04 dated 4th February 2025 under the provisions of section 107 of the WBGST/CGST Act 2017, hereinafter referred to the said Act, for the tax period
1819.
Where do I get it? You are getting it, it will not do. I need to see it.
Adjudication order page 45, my lord, period of
Where?
2018-19.
2018-19.
My lord.
In the column on the box.
Where?
The box, my lord,
In
your
the box,
lordship,
top
first
box. Top box, last line.
Last line, GST and legal name, trade name, period. Page 45.
Page
At the top, my lord, the box, that column.
Yes. 2018-19. The instant writ petition has been filed. Having heard the learned advocate. Yes.
Well, this is the matter under the Central Sales Tax Act. Well, to get the benefit of concessional rate of tax, my lord, a petitioner is required to produce the declaration in Form C obtained from the customer, my lord. We produce the declaration in Form C before the concerned divisional authority, my lord. The authority rejected my part of the claim, my lord, on the ground that it is not, my lord, ascertainable.
There is an appeal.
Before your lordship.
So it cannot be decided without exchange of affidavits, my lord.
Without exchange of ideas cannot be decided. Page 49, my lord, there is a divisional board's order. Wait, the calculation.
Page
49.
Well, kindly come to last page, my lord, page 57. which I am telling.
Oh, this is by the West Bengal Commercial
Bengal
Tax
Commercial
Appellate
Tax
Tribunal Board.
Yes.
Under the Central Sales Tax.
Well, I am aggrieved by the order at page 57, madam.
The entire order, page 49.
Yeah, aggrieved me. Nice, see portions.
Yes, what is difficulty in the order?
So kindly come to page 57.
I am on that.
Yes, madam.
Form C was issued
No,
in respect
it
of
has
before
been
the
found,
transaction. Yes.
but it has been found on checking that 11 number of Form C were issued prior to the date of assessment involving 5 crore 68 lakhs. But my contention is this, that the declaration in Form C can be produced at any stage, madam.
Show me that.
Though, madam, yes, madam.
Show me that law. Are you clear? From the order, it cannot be. Order is going against you. Show me the law.
Yes, yes, madam. Kindly come to
Yes.
Section 8(1), my lord, the provision.
এই সেন্ট্রাল এক্সাইজ দাও না আছে এখানে
Central Sales Tax Act, my lord.
বের করো ততক্ষণ দেখি you have only one copy. No, you keep it. কোথায় রাখছো? ওই তো পরেরটা যাও আর পরেরটা দেখতে পাচ্ছি তো। আরে ওইটা হাই তো হ্যাঁ দাও। Yes. Central Excise Act?
No, Central Sales Tax Act 1956.
So, Sales Tax Act.
Lordship, takes we have other book also.
Well, I'm sorry, ma'am. May I hand over my book, my lord?
It will be easier for you. Place it from you.
Yes.
You retain your file. Yes. Yes, which one?
Well, kindly see section 8, subsection 1. Every dealer who in the course of interstate trade or commerce sells to a registered dealer goods of the description referred to in subsection 3 shall be liable to pay tax under this act, which shall be 3%. Well, this is the concessional rate of his turnover or at the rate applicable to the sale or purchase of such goods inside the appropriate state
Yes.
under the sales tax. Now, I will kindly come to section 8, subsection 4. The provisions of subsection 1 shall not apply to any sale in the 8 subsection 4, my lord.
Every dealer.
No, the provisions of subsection 1, section 8, subsection 4, my lord.
So this is rule.
Section 8 continues, man. This section 8 continues.
You have given me the rule to it. Doesn't it? Yes.
The provisions of subsection 1. My lord, kindly read, my lord, section 8, subsection 1.
Yes.
Every dealer who in the course of interstate trade or commerce sells to a registered dealer goods of the description referred to in subsection 3 shall be liable to pay tax under this act, which shall be 3%.
2%.
Well, it was
amended.
Yes,
Very
amended. Of his turnover at the rate applicable to the sale or purchase of such goods inside the appropriate rate under the Sales Tax Act, Sales Tax Law of the state, whichever is lower. Now, well, kindly come to section 8, subsection 4. Well, 3% is or 2% is the concessional rate. Well, the provisions of subsection 1 shall not apply to any sale in the course of interstate trade or commerce unless the dealer selling the goods furnishes to the prescribed authority in the prescribed manner a declaration duly filled and signed by the registered dealer to whom goods are sold containing the prescribed particulars in prescribed form obtained from the prescribed authority. So, well, to get the benefit of
this is a proviso.
Yes, ma'am. Provided that the declaration is furnished within the prescribed time or within such further time as that authority may.
Well, so there is a time limit. Now come to the rules.
Yes, ma'am.
Come to
Rule
the rules.
12,
This is
Rule 12.
Obviously,
Yes.
rules must be there on this.
Yes, there is.
You know better, sir.
Well, Rule 12.
Yes. Rule 12 is offences and penalties.
Of the CST WB rules, West Bengal rules. There are two rules.
Achha, I see West Bengal. Very well, I got it. Yes. Yes, Rule 12.
Yes, ma'am. Placing it. Now, kindly come to 7, Rule 12, sub-rule 7.
12(7) कहाँ पर है?
Here, Rule. Well, kindly come to 1, Rule 12, sub-rule 1. The declaration and the certificate referred to in subsection 4 of section 8 shall be in Form C or D respectively, provided that Form C in force before the commencement of the Central Sales Tax Act registration amendment rules, before the commencement of such and such as may be prescribed. Provided further that a single declaration may cover all transactions of sale which takes place in a quarter of a financial year between the same
Rule
two
7.
dealers. Well, Rule 12, sub-rule 1.
Rule 12(1) is all right. Come to 7, sub-rule 7.
Yes.
That is the relevant rule.
The declaration in Form C or Form F or certificate in Form E.
Within 3 months.
Well, thereafter the time can be extended.
Yes,
that is
can
not
be
that is not the dispute. I was allowed to produce the declaration in Form C. They are saying that these I cannot ascertain as to whether these forms were earlier produced before the assessing authority or not. This is the ground, my lord. This is not the ground that the time was not allowed to produce the declaration in Form C, because he has allowed my part of the claim on the basis of those declaration in
No,
Form
the
C.
order is different.
No, my lord. Kindly see, out of 11,
The order
I
says
114 crores formed, my lord. He allowed 112 crores. 5 crores he disallowed on the ground that I cannot be ascertainable as to whether these forms were used earlier.
No.
Yes.
He says it has been found on checking that 11 number of
Form
Form
C
C were
were
issued prior to
the
days of
date
assessment.
involving such and such. Rest of the Form C were issued after the date of assessment. Has claim of sale under section 8(1) of the CST Act further allowed at this stage. So that he allowed part of my claim. But in respect of 5 crore, he is saying that since it has been issued prior to the date of assessment, my lord, it was issued to the sellers by their assessing authority. But I received afterwards. And my lord, there is no allegation that he has verified the records of the assessing authority.
Law. I'm not convinced though with whatever he says.
No, Lord, he has to verify. My lord, what I am submitting. Suppose, my lord, at the first stage, before the assessing authority, I have produced certain declaration forms. His contention is this, that whether these forms which I have produced are allowed.
Come after the vacation.
Yes, my lord.
Come after the vacation, this matter.
Well, it's clear, my lord. He has.
I
Well, the authority has,
you have to convince me, sir.
yes, what I am submitting, my lord.
I am not yet convinced on you. That's why before the vacation is not possible. Come after the vacation.
Well, what I am submitting. In case the authority was not satisfied.
I will hear you on the entirety.
Yes.
Unless I am convinced and not pass an order in your favor. Very clear. Neither will I dismiss your matter. I will place it after the vacation.
Yes.
You want to argue for the entire half, argue it. I will hear you. Please, after the vacation.
Not in the monthly list, my lord, just after.
Monthly list, it will be taken up. একেবারে
will not, my lord, monthly list means, my lord.
দেখো না, not today করে দাও. Not today করে দাও. Order দিও না. Not today করে দাও. Motion 5 থাকবে. I'm not passing any order. It will automatically there at the top. Yes, call the list.
Number 14.
Well, this is the case pertaining to under the GST, my lord.
Yes.
Case pertains to the year, my lord, 2020.
If you consider any matter which will require serious consideration,
168, 168, 2019-20, my lord. Well, the last date of filing of the annual return was, my lord, 31st March 2021. So normal period.
I'll take your matter later.
168.
Let me take the group 4 first.
168 in the month of December.
Are you in hurry?
No, I'm not in a hurry at all. He's always in a hurry.
Judgment.
Wait, Mr. Chatterjee.
I'm here, Mr. Chatterjee.
Yes.
So, my lord, for the period 2019-20, my lord.
Where is any order is there?
My lord, I have brought. But it relates to period, my lord, 18-19. My case is, my lord, pertaining to period 2019-20.
Challenging the Disposal of the writ petition.
I'm grateful.
Yes, next. Liberty to affidavit 6 weeks, 4 weeks.
चल same order. Order नहीं का. Same case, same officer.
What's in?
No, the last day, relax class. I'll call after the group 4 is over. That's why I asked Mr. Chatterjee is there. Just wait for a while. After some more matters, I usually take till 1:30.
I appeal.
Yes.
But here, the subject matter of challenge is a adjudication order and a show cause notice. The issue relates to verification of transitional credit in Tran 1. I filed my Tran 1 form in 2017. I took credit of only service tax because I was into service tax regime. Now, service tax department, when it converted to GST, the CGST department since 2018 issued me notices. I submitted all documents over a period of 5 years. All the documents, there are acknowledgements which have been submitted.
He's disputing that you have submitted.
Lordship has already.
Lord, reflected in adjudication order, he has not submitted, neither to me, not to the central authority.
Then, Lordship, suddenly the state GST now. All the documents were sought to be by my proper officer, which is the CGST authorities, because the transitional credit was being taken by them. Now, suddenly the state GST issues me a notice under 74, alleging suppression on 14th of June 24.
Come after the vacation.
Lordship, I dealt this issue, same issue in case of Eden Real Estate. I have attached that order.
Remember that. But that is very tricky. So come after the vacation.
My only
do not have any urgency in this.
my urgency is there, Lordship, because 3 months of the adjudication order is about to expire. Because now what will happen, I explained your Lordship, now they take away from portal, their officer will not do. But if there is any balance in my portal, it is auto debited.
He has to
When it will expire?
on
Lordship,
5th of February.
5th of February 2025.
He has to first satisfy your Lordship, my Lord, whether he can, my Lord,
I'm not entertaining it.
bypass the alternate remedy
I will.
before your Lordship.
Correct. So
I will satisfy.
I'm not entertaining it. Tell me.
5th of February,
Adjudication order.
February.
5th of February, 5th of March, April, May.
No,
And
not like that.
5th of June.
No, not like that. There are 2 days, 3 days in between in February. 28, 29, 30,
Lordship, it is
31.
month. In this case, it is month, so it will always go back to that date. Your Lordship has already stayed one order. Your Lordship has stayed one order.
Yes, so 5th of June.
5th of June is the extended time, Lordships. Extended time is 5th of June. I came before your Lordships much on very
Come on the reopening date. On the reopening date, Mr.
kindly take up
Kanodia,
tomorrow, Lordship.
nothing will happen. No. Because
Lordship may pass one line order that Lordship, one line order that no action in the meantime be taken. Just
Your Lordship can pass the
Lordship, till that returnable date, Lordship, because
What
I
I
can
do-
file application also.
what I do, you are aware.
Lordships will redo it.
Either I will pass an order in your favor or I will not.
Lordships, that is, I am not on that. I am only because your Lordships, there is a 2 weeks gap.
Then not today. Let's see tomorrow. Let's see. If it's not today, it can't be taken up now. There are other.
Lordships, tomorrow.
Let's see. It's not today.
Lordships will not take daily list. I know Lordships will take monthly list.
Monthly list I will not take.
Lordship, give some.
Monthly list I will not take in between this period. Yes, call the list. Only urgent matters I will take.
This
No,
is only because of recovery. Otherwise, I was not.
let us see. Nothing will happen.
Note 16.
16, I am for the respondent number 1.
Yes, madam.
Time for the petitioner, my lord. My lord, this is a customs matter, my lord.
Yes.
And we have challenged the issuance of a show cause notice here. Reason being, the department has issued me a show cause notice on 9/1/2025 for the purpose of finalizing an assessment which has already been finalized in the year 2009. So my assessment, which was provisionally done initially in the year 2004, stands finalized in the year 2009. Now in 2025, they have again issued me a show cause notice that we want to finalize the assessment.
Show me that.
My lord, my lord. My lord, kindly takes up page number 49.
Yes. Who's appearing?
I am for the not
Union of India will not do. Who is appearing? Yes. I'll appoint you. But appointing you will not do. You have to take instructions. Yes, madam.
My lord, kindly takes up page number 49.
He cannot appear alone. His leader he has to have a leader.
48, my lord. apologies. My lord, 48, this is one letter that I'm referring to, which was issued to me in the year 2012. My lord, kindly takes up page 44, the first paragraph. My lord, the second last line from the first paragraph, it says, the importer furnished the required documents on 29/3/2008 towards finalization of the instant project import case, which was finalized by refund order dated 8/5/2009 with refund of security deposit.
48.
My lord, if my lord comes to the my lord, page 48, my lord has got.
Yes, however, it is noticed that a copy of that line, that paragraph, which paragraph are you placing?
My lord, page 48, end of the first paragraph. The paragraph starts at, it is seen that. My lord, actually, there are two cases of Tata Hitachi only. Is my lord holding the brief for 9605?
Yes.
My lord, page
Paragraph 45, 48. It is seen that the top. Yes,
yes.
yes.
My lord, that same paragraph, the last line or the second last line.
Yes.
It starts from the importer
Ah.
furnished the required documents on 29/3/2008 towards finalization of the instant import project import case, which was finalized by refund order dated 8/5/2009 with refund of security deposit. So, my lord, it is their document which was issued to me. In that document only, my lord, show cause is in the next page. It is issued to me on 9/1. My lord, this is the first show cause. My lord, to the best.
24th September 2012.
My lord.
Was there any show cause issue?
No, my lord, that was a letter. That was only a letter which was issued to me. The show cause, to the best of our understanding, because these are very old matters. My
This is
provisional
done under which
assessment,
provision, madam?
my lord, they are doing it under 18, section 18. Finalization of provisional assessment, section 18 of the Customs Act, my lord.
Yes, madam. Customs Act Section 18 is provisional assessment.
My lord, subsection 2.
Yes.
When the duty leviable on such goods is assessed finally, in accordance with the provisions of this act, then my lord, whether something will be refunded to me or not, that it is said in the goods cleared for home consumption or exportation. So,
in what form that shall be issued, madam? Is there any form in the Customs Act?
my lord, it's an order. My lord, provisional assessment, then final assessment, they will issue me an order.
Rules, no.
No, my lord, they will issue me an order after the provisional assessment is finalized.
So it says, in case the goods are cleared for home consumption or export such and such against deficiency in case of warehouse goods, the importer shall be liable to pay interest at the rate fixed, subject to subsection 5. A refund amount lost to shall not be refunded. Subsection is not refunded. Very well. Yes.
So, my lord, my main question here is this: I asked to myself only: can the department now be permitted to issue a show cause notice to me after all these years, 12, 15, rather 20 years from the date of provisional assessment? From the date of provisional assessment, 20 years. From the date of finalization of assessment, 12 to 15 years. So, after this delayed period of time, can the department now issue the show cause notice? My lord, page 49, kindly, my lord, takes up.
They acknowledge this letter, page 47.
My lord, this is their letter only.
They acknowledge this letter.
My lord, this was given.
In their show cause, do they acknowledge?
My lord, there's a reference. I will show my lord.
Yes.
Paragraph 3, my lord. Whereas a letter dated 24/9/2012 was issued by the department. So this is the same letter I'm referring to in page 48, my lord. My lord, the bill of entry number is also same.
Yes, you did not comply with the direction.
My lord, this was a letter. So this
is you did not comply with the direction.
Then, my lord, assuming that because these are very old records, my lord, I do not have possession of them right now. Assuming that I did not answer to this letter, they could have issued me a show cause notice then and there. I was in possession of the documents at that time. I would have been able to show it to them. If a show cause is issued to me after
the general period of limitation is 3 years, Mr. Bhattacharya. General period of limitation is 3 years. General period of limitation. And a special period, special act, maybe special periods. I'm not saying so. But you show me that after so many years you can, because if you refer to this letter,
As I have understood from the
how can you proceed? Then after decades, how can a person reopen his books? How can a person be called upon to produce? Practically, she was in a position to, the petitioner was in a position to demonstrate this letter. The lucky stars for them after so many years, 2012, after 10 years. Usually people do not retain such documents. Not everyone. Not everyone. How big the business house, I do not know. A Tata Hitachi construction. So they may have retained it.
that was the exemption, my lord, in respect of my lord duty exemption. In the letter, if you also will
So
consider.
no, it is all right. I understand, Mr. Bhattacharya. Take instructions in this matter. Till such time, do not proceed. Reopening date, only this much. Till reopening date, till the next date, just do not proceed. Because asking them to respond to this after so many years, it is difficult for them to respond also. Otherwise, ordinarily, I would have directed them, go and respond. What they will respond after? Maybe all the documents are not available. Have you said all the documents?
My lord, we have said.
Which paragraph? Which paragraph?
My lord, I'm just coming. My lord, 1 minute. My lord, 13, 1, 3, 13. Page 6, my lord, paragraph number 13. And my lord, page 7, paragraph number 15
Yes,
also.
Mr. Bhattacharya.
My lord, kindly see page 52
Yes, yes.
of the writ petition, my lord. They have given a reply to the so-called notice and asking us, my lord, for giving an opportunity of personal hearing. Therefore, my lord, he will attend the hearing. He himself will consider it as a jurisdiction to the so-called notice, my lord.
My lord, this is a letter which we had given. In the letter, the subject of the letter and the contents of the letter.
Very well,
clearly
madam. You
state-
go there and you respond.
My lord,
So
we-
final order will be, I'll protect you, madam. I'll protect you.
My lord, then the. My
I'll
lord,
protect you because I understand the situation. Maybe, but you have not taken that stand in the letter.
my lord, in the letter, it is clearly mentioned that we don't have documents.
Where have you said so?
My
Where
lord,
have you said so?
paragraph 6, we do not, we have page 53. We also wish to submit that SCN has been issued beyond a reasonable period of time.
No.
We request your then paragraph 5.
For explaining that part. For explaining that part. No. These are not submit to the use.
My lord, my lord, kindly see.
I will. On the next day, you take instructions and come back, Mr. Bhattacharya. I'll not detailed order. So, therefore, once I pass a detailed order, then it will continue. I'll not pass a detailed order. That's it.
Only what I am suggesting, if you subject to your lord's permission, my lord, if my learned friend wants to participate in the so-called, my lord, that is his
They are saying that they don't have anything. They have said so. Paragraph 6.
11 can see page 55 can see, my lord.
Yes.
Page
Para-
55, para 11, my lord.
To bring the records, Mr. Bhattacharya, I think that will be better.
That is a
Maybe they are not showing something. Not that suppressed, but maybe something is not there, which the court needs to see. When you bring it, I'll consider it. I'm not deciding, admitting that.
Let them attend the hearing, my lord. In the meantime,
No hearing they'll attend. They have made out a case.
In the letter only.
We shall not, my lord.
They have made out a case in paragraph 6. Kindly come to page 53.
So then what about their letter? Reply to
Yes,
the
this is their letter.
Well, otherwise, they will only say we have not responded.
A person will not respond.
Documents.
They have to show their bona fide. What is their stand? Prima facie, they have shown that.
Well, at paragraph 5, we have stated that we please provide us with the documents because we are not in possession.
Very well.
Let them take it.
Challenging the show cause notice dated
My lord,
Okay,
17
Mr.
also, the
Tangvi, so
underlying-
far as the other matter is concerned, in the original side, I've directed to appear as to be mentioned. Please appear. Yes, yes.
17 also, similar issue.
17, same issue.
Similar, what has happened here is in the first matter that I was just
After recess, I'll come back and no 7 or
Monthly.
after recess, I'll take up the monthly
Yes, my lord.
matter. So it's gone after vacation.
Same issue only, underlying issue is same, that whether they can proceed after 20 years or not.
Take it out.
Because in the first matter, the only difference is we had this letter. We had this letter from the department dated 2012, wherein we came to know that a finalization was done. But for the second matter, we know that the provisional assessment was done in the year 2002. Here, the show cause is issued to me on 6/1/2025. So, my lord, the underlying issue, whether a show cause notice can be issued to me after 20 years, this is the only question that ought to be adjudicated by my lord.
When I've been directed to appear.
My lord, show cause notice.
This one I'll take after recess. I'll take it after recess. After recess. Yes. Call that matter. You have to wait for a while. What can be done, sir? You see, I have to do my part of my job.
My lord, regarding the item number 18, my lord, kindly after vacation, my lord.
18.
18. 18.
What was her number? Why do you want it?
Oh, after vacation, my lord.
Yes. Yeah. Doesn't want to do it now because he has a difficult case. He want to do it now. No. Yes, sir.
My lord, kindly seize the last order, my lord.
Just a minute.
Yes.
Who's appearing?
My lord, I for the state.
Mr. Nayak was
Mr. Nayak is appearing, my lord, for the
my lord, direction was given to yes to
Mr. Nayak?
instruction.
Cannot be any difficulty. Yes. Very well.
My lord, we have threefold prayers, my lord. We have threefold prayers. Before that, my lord, what?
Mr. Chatterjee, everything. I want me to dispose of the petition.
No, not at all.
What is your prayer?
We want that the ballot boxes and the CCTV footage is to be preserved, and the formation of board is to be kept in abeyance till
No, that I will not.
Kindly, my lord, what happened? Then, my lord,
that I will not.
My lord, kindly,
Sir,
kindly
Mr.
allow me for 1 minute.
Mr. Chatterjee,
My
I'll reserve your right
My lord.
and permit you to apply under Regulation 35 of that West Bengal Cooperative Societies Cooperative Election Commission Regulation 2012. I permit you there. It will be decided. I'll protect you. Today, that will be usurping the powers of the commission without deciding on the cause, Mr.
Within
Chatterjee.
1 month, we have already applied before the.
I'll protect you.
My lord, grateful.
I'll dispose of the writ petition.
Right now.
My lord, why? What do you mean? Tell me, Mr. Chatterjee.
What happened, my lord?
I will direct the court's order. I'll record his submission.
My lord.
Anything is there, you come back. Anything, ballot boxes, the CCTV cameras, I've already indicated.
Yes, my lord. What
Who is
happened?
appearing for the election commission? You will do it. You will do it. And direct you to file a report on the returnable debt.
Grateful, my lord. এই ছবিগুলো দেখি একটু
Correct. So I will not interfere, Mr. Nayak. You have heard me. But why will you not? You are a commission. You are not siding with anyone.
Boss for 6 books. Box could not be placed. That's why election has been suspended. And this election is under process for 6. And that is
Very well. For six under process.
Yes.
The rest has been done, completed.
My lord, we do not have any
Complete and
instruction.
declared.
No, we do not have any
What is your instruction? Give me, Mr. Nayak.
আমাদের হ্যাঁ let a copy.
I'll record it, Mr. Hey, thou.
No.
Yes, Mr. Nayak, tell me. Oh, this is your first. Which paragraph? Which paragraph? Yes.
Second paragraph.
Yes.
It says here that the result of 24 seats out of 36 of delegates were declared on 4-5.
24 seats out of 30 delegates. Out of 30 seats of delegates were declared. And the result of 6 seats could not be declared as the polled materials, including the ballot boxes, were not submitted at the receiving center.
চিন্তা করুন my god my lord, we have the photographs how the presiding officer was attacked, my lord, how he was assaulted, and my lord, the chappa votes are giving my
No,
lord.
then Mr. Nayak, having regard to the complaint nature of you cannot proceed with the fresh elections.
Grateful, my lord.
No,
Grateful,
no.
my lord. Grateful, my
No,
lord.
no.
We are trying to proceed with the elections which we have won.
My lord, we have.
But you did not make any such prayer.
Yes, my lord.
Where is your prayer?
Yes, yes, yes.
I'll grant you leave
We
for
have-
that to move vacation bench. For that to move vacation bench because there is no prayer for that. You did not include
We
such
have
prayer.
prayer. We have
1
prayer.
minute. Only
We have prayed. We have prayed for repoll.
Only
have
1
prayed.
minute, Lordship, kindly allow me. Thing is this, my lord, election commission independently has judged the situation. And before coming to this court, they have independently taken
Today, Mr. Nayak, listen to me. Today, I don't want to hold you back to the lunch, entire lunch period. Lunch will go. Today, Mr. Nayak, today, Mr. Nayak, learned
No, I want to.
I am not interfered that. I only want to see the report on the returnable debt, and I have granted them leave to proceed.
Well, a copy of the report.
Mr. Chatterjee, be very clear that what will happen. Don't be under any impression this court is going to decide this.
No, not that, my lord. My lord, can we get a copy of the report?
Yes, yes, from my officer will get.
Kindly record, my lord, by one line submission, my lord. This has not received any kind of,
Eh? Absolutely not. We have lodged complaint.
I will call for the police authorities. Apropos the election commission's this particular stand taken, I returnable date. What has happened?
Steps police have
And you
taken?
proceed with the matter.
My lord,
This is only the.
what steps police have been taken? Yes, what steps you have taken? Report দেবে আমাদের।
Motion.
A copy of the report, my lord. We shall take a photocopy
We'll
of
give
the
it to
report
you.
and return. my lord.
Kindly record by submission, my lord. Don't
Yes.
by submission.
Yes, yes.
Police has not received any kind of.
You want me to investigate there also? I will record your submission.
Let it be filed by affidavit. Let it be filed by affidavit that they have not received any complaint.
My lord,
They have not received any.
Since I like since out, sir.
That's how I am submitting.
লোকটা চাকরিটা গেল।
Proof is required.
You see, at the end of the day, whatever you do, you have to continue within the four corners of the rule of law. You cannot stand outside that, whosoever it is. Whosoever it is, be it the petitioner, be it the respondents. And the election commissioner has taken a very fair stand. They'll also file a report. I want to see that. And Mr. Naik is there, I'm sure. There will be no difficulty.
We shall try our best.
Yes, yes.
In this matter, my lord had passed an interim order wherein the departments are prohibited from communicating the assessment order to us. The assessment proceedings will go on. Subsequently, your lordship, the departments have passed the assessment order. They communicated that along with penalty notices. Your lordship had mentioned the matter before my lords. My lord had suggested that I file an application, my lord. I filed an application, my lord. I'm humbly praying if that, my lord, that matter may be taken
After
up.
the vacation, please. Cannot be any urgency. You won't know what is the fate. Have to hear what you have communicated the order or not. That's the only issue.
But they were represented as well. We communicated even the other side.
Very well. After the vacation, file it. I'll take it up.
You already filed it.
I'll take it up after the vacation. First Friday it will be taken up.
Your Lordship, I crave leave.
Because this Friday
I understand.
long-standing practice I would not take up. I would not take up matters.
Your Lordship, I crave leave to mention item number 19 of the daily supplementary
Why am I
list.
mentioning now?
Your Lordship, I just want this supplementary affidavit be kindly taken into record.
Wait, another matter is going on. There is another matter. Yes, call the list. Dakota.
Item 97 in the monthly list, if it can be taken up today, it will take 2 minutes.
Let this matter be over first. I am continuing with this matter.
Great.
Yes, who's appearing? Where is Mr. Mukherjee? Yes, yes.
My lord, in this matter as well, the issue remains the same. My lord. My lord, show cause is at page 30, issued to me on 6/1/2025. My provisional assessment for the bill of entry was done in 2002. In the last matter, I had a letter from the department stating that on such and such date, there was a finalization. However, to the best of our knowledge, my lord, here we don't have any record. So we are not certain if it was finalized or not. Regardless
so I
of that,
think it is not been finalized.
my lord, remade regardless of that, even if I assume it is not finalized,
If it
even
has not
then,
been finalized, they are not entitled to finalize it.
my lord, after 23 years, that is my only point of contention, my lord. My provisional assessment done in the year 2002, there could have
Where
been...
do I get it? Provisional assessment done 2002.
The bill of entry number is there.
Where?
From the show cause notice only. Page 30, my lord. Page 38. Page 31, paragraph 5. Bill of entry number 538 dated 13/2/2002. So the date
13
13/1/3/13/2/2002.
Which page?
Apologies.
Which paragraph?
Para 5, my lord. At second line, it says bill of entry, manual bill of entry number 538 dated 13/2/2002, along with the things were finalized. So this is the bill of entry that they are talking about, wherein they have issued a show cause notice now for finalization of this. So
Yes,
date is 2002.
Same point. Yes. No, is it your case that bill of entry is of 2002?
Why? That has also been clarified. Why? Whereas since reconciliation statement furnished by the importer is extraneous, it stands to reason that...
When did he fund his reconciliation statement? When? Last year? This year?
2007.
Thereafter, it stands to reason that the has furnished to the department a document that is used by them to contain false information, thereby making them liable to incur appropriate penalty under section 140(3). Thereafter, whereas it is also observed from the record that the importer changed their name to Method Tata Hitachi Construction Machinery Company Limited from their Basis Stelco Construction Equipment Company Limited without intimating our department under relevant sections of the Customs Act, due to which some letters asking for documents for finalization of the instant project were returned back by the postal authorities.
How was the change of name affected?
My lord?
How was the change of name affected?
Lord, change of name, there is this IEC code. So all the details get uploaded there. If this thing...
Was it pursuant to a...
Well, they merged because of a merger, my lord.
Yes.
Without notifying our department that there is a change of...
Madam, you know merger is notified. The order itself notifies. Central government's views are taken prior to a merger. Anyway, I'll examine this. Today, I am not going to hear out the matter, Ms. Mukherjee. I cannot hear out the matter today, Ms. Mukherjee. Please understand. I will give you opportunity in the next date. Come or bring all records on that date. Yes. Show cause should not be entertained. That is the first preliminary objection.
The documents that were sought in return, the postal authority returned this date. So, my lord, our NGO communicate them. Have paid because of their own action.
When did you come to learn that they have now been renamed? When did you first come to learn that they have been renamed? And from which period to which period were you aware with regard to? There are a lot of questions you have to answer, madam. Without records, you cannot. So, this is not no argument off the cuff. It's not possible, madam. Yes, Ashok. Challenging the show cause notice dated.
We are the show cause date.
Dated, madam, dated.
6/1/2025.
6 January 2025, issued under the provisions of section 18 within bracket 2, comma 18 within bracket 3, comma Bring all documents, records. Then this go to Ganges. Once you file affidavit, then you are accepting the stay. The stay will continue forever, madam. If you can next occasion come and show, you see only thing suppression. If they have suppressed, I will take it from you, from directly from you. Suppression, I will vacate the order. No, not necessary. Suppression, I will vacate the order. But if this is no suppression, if some material is there, counter allegations are there, then naturally you have to be. So I'm giving you that chance till the next day. Yes. Yes, which matter is yours? What is the urgency?
97. The only thing is that 168 notification under challenge.
No urgency, sir. If I can take it, I can reach, I will reach.
Only difficult.
I will reach, I might reach, sir. Wait, I might reach
Yes,
also.
otherwise
Yes, yes.
I'm
Call
not
the monthly list. Call the
June,
monthly.
I'm not available, my lord. Otherwise, if not reached, then July, my lord.
Yeah, very well. I'll keep it in July.
Lordship, item number 19 of the daily list, your lordship, if I may be permitted to put this supplementary affidavit on record.
No, not like this. No supplementary evidence without hearing who how come I grant. On the next occasion, it will be there in the list. Maybe called on tomorrow also. Let's see. Tomorrow also there is a chance. Though very bleak. Most of the matters which were there have been taken up.
Monthly list item number 66.
Lordship, my senior Sri Porak Kothari is not keeping well.
Take file.
Kindly fix this matter.
You are not ready? Yes, you are not ready? Yes, madam?
No, Lord.
Why? Take file now. Why are you not ready, madam? The opponents are there waiting for you in the matter and you are not ready. You did not intimate them that you will not move. What is the challenge, madam?
The adjudication order was passed. The amount pertains to 99 lakhs something.
Central excise. This is central excise.
Yes, sir, service tax.
By the Commissioner of Appeals, Commissioner of CGST.
Yes, CGST. Was also filed, Milord. That was rejected.
So she has that has to be heard by this court. This union is submitting.
The read they have filed.
In read court, there is no pre-deposit.
Before the appellate authority, your lordship, they have not deposited the pre-deposit, 7.5%.
Oh, I see. Where is that order? Show me that. Tell me. Indicate that.
At page number 39. Last page of the read.
Yes, madam. Are you ready and willing to put in the pre-deposit?
No, Lordship, I am.
No. Do you have instructions? You are saying no. Come to page 39. You have a petition with you? Share the petition, Ms. Mukherjee. Read the discussions and findings. Achha, this is disputed tax and penalty.
The amount is almost 1 crore, the tax amount.
একবার দেখি এই সেটেল এক্সাইজ দাও তো এই তো এখানে দিলে না সকালবেলা দাও তো এখানে নেই এক্ষুনি দাও তো হ্যাঁ দাও তো Why are you insisting for penalty, madam? This is from which state? West Bengal.
Yes, your lordship, West Bengal.
not submitted any clarification or explanation document even after repeated communication.
No, no, where is your right to recover this pre-deposit? Show me from 35E. Percentage. Yes, madam. Thirty-five eight says so much as may be directed. Mandatory pre-deposit. I want to see that mandate. Which section? Tell me.
35F.
35F.
35?
F,
Book is not available, central excise. If the applicant has
Yes, and penalty. When is that matter fixed? Mr. Who was appearing in that matter? Mr. Shandal, not Mr. Shandal. Mr. Bhomik was appearing in that matter. Today in the morning. Mr. Ganguly's junior was appearing. Yes, same issue, same point involved, perhaps. Yes, yes. When is your matter fixed?
Customs matter,
Correct, but the language is the same. Language is the same. Here also there is no comma.
Universal book.
Universal. There is no comma.
There is a problem.
There is no comma.
In universal.
When is your matter fixed?
My lord, after vacation, my lord.
Date.
No date was given, my lord. After
Which
vacation.
is your item?
Monthly list of June. Ajker item number. Item number 4. Serial 4. Item number 4, my lord. Today's list.
ওইটা না পরপর দিয়ে দিতে পারবে ওটার সঙ্গে এটাকে ঢুকিয়ে দিতে পারবে What is your name? Yes, বলো মনে আছে হ্যাঁ ওইটা month is of June. As a last chance. Madam, as a last chance. Get ready and come. If your senior does not come, which most likely he will not come, you argue the matter. Whatever you can, argue the matter. Next.
I've been told that. My lord, actually, in item number 17, while my lord was passing the order, my lord asked me what happened to the companies. It was a wrong submission. They have not merged, my lord. It is a joint venture company. So that was it has not the name has not changed because of a merger, but the two companies, they have come into a 80-20 joint venture stake. That is why the name has changed. So it will not be
Where is
pursuant
your
to any order.
certificate of incorporation?
My lord, that I have not annexed, but if I may.
Fresh certificate of
But
incorporation.
then IEC code, my lord, that I was saying, IEC code, it has all the importer, exporter are supposed to have that. That code, once you click, it is issued to me by the DGFT authorities.
ওনার যে সাবমিশনটা আছে মিস রয়ের ওটা কেটে দাও পুরোটাই you come back on the returnable date, you find yourself in difficulties. What of bother, madam?
My lord, but
with all your documents, whatever you have,
my lord, we don't have documents. That is the only
Then
problem, my
gone.
lord.
then it is gone there.
My lord, then
This matter, the show cause will survive. Come
my lord,
back
but
on
then,
the next date.
then, my lord, the show cause should have been issued to me earlier, my lord. Now, after 20 years, how does that
Come to learn
come?
with regard to that. I'll give them the benefit in that case. I'm not disturbing you now. You ascertain what instructions you have, and then you come back on that date.
Now the submissions goes, then Lord's order.
Absolutely, no.
My lord,
Second part.
other, my lord, just the
First part,
merger
the
cut,
delay
my
is
lord.
still there. Now, in this, I will test out to balance the equities whether you had been prevented or not. That is why I'm calling for the records.
Yes.
My lord, because
To
the,
bring it,
Whether the relevant date comes to.
yes, I'll bring it whether reasonable or not. That's
my lord, because in between we had replied also.
let them come up with whatever they want.
My lord.
With documents also.
My lord, documents only, that is what we had written in the letter.
Copy of whatever.
No. You will not disclose the records. So let her come. It's on the reopening, only 2 or 3 days after the reopening. 18th.
18th, my lord, 18th.
18th.
Whatever they are filing in court on the next day, joint venture or some other.
They'll disclose to you.
Hello. Prior to the date.
Yes.
My lord, will serve.
3 days
Will serve, my lord.
Whatever. Give her advance copy. No,
My lord,
you
my
can't
lord.
hold back documents, madam.
My lord, will serve. My lord,
Yes, call the next matter.
Well, I am for the petition.
Mr. Bhattacharya is there in this matter. He sought for some.
Which Bhattacharya?
Uday Shankar Bhattacharya. Sought some accommodation. He is on legs in court number 1.
Not called on in that case. After vacation. Yes, next.
Well, I am for the petition. But here, goods were detained, and thereafter, well, the penalty was imposed under section 129 of the GST Act.
Appellate authority has already passed an order.
Well, the only ground, is, my lord, that the vehicle was found at the address which was not, my lord, appearing in the e-way bill.
I have to hear you.
It is a case of
This is the only.
I have to hear you.
Yes.
You are challenging an order passed
Yes,
by the appellate
appellate
authority,
yes.
confirming the order under section 129, 129(3).
129.3, my lord.
Right.
Where is that order? Appellate order.
So that page your lord will find. Page number 79, my lord.
Challenging the order passed new opportunity. Yes. And although Mr. Siddiqui, you see, you have argued that our court has negated, some courts have upheld. Matter is pending before the Supreme Court. The issue with regard to the outer limit. Now, this is not one appeal. System is a multi-tiered one. The person is out of time in one stage. But from that order, he is in time from the second stage. See, it cannot be that the tribunal, appellate tribunal, will not go into the merits. If that is so, if that is so, that the appellate tribunal will only consider what is there in the order, then the
Will go into the merits, but if it is
the moment it goes into the merit,
but if it is time barred, my lord, it
no, the moment it goes into a merit, despite being time barred, because from the appellate order it is no longer time barred. Maybe we are considering a situation, original order is time barred. Appeal is time barred, 107 rejected. An appeal is filed there from 112 in time. In time.
that appeal cannot be admitted.
No, correct.
Subject to, that's subject
No,
to correction.
in time. In time. Appeal has to be heard. Appeal is in time, appeal has to be heard. Whether what would be the scope of appeal is a different issue. He cannot say that I will not accept your appeal. He is bound to accept statutory appeal.
You will hear it and then
Correct.
there are
Now, since it is a statutory appeal and considering the scope of GST, here you see a period has been provided under the act. What has to be done under which particular date? Now, there are so many formalities which are required to be complied with.
still, my lord, there are innumerable judgments with regard to revenue law.
Those are in respect of excise matters.
No, even, my lord, income tax matters, even
Correct. Income tax matters also.
VAT matters, my lord. Even VAT matters.
GST considering there were no multi-tiered statute, multi-tiered adjudicatory process available.
Because, my lord, these cases, my lord, since revenue is involved, so, my lord, it cannot be, my lord, that a person files an appeal after an order has been passed by an adjudicating authority, and we seek to, my lord, raise the demand. We seek to recover the amount, and after 1 year or so, a person
By
files
the
an
time a person challenges and goes to the tribunal, 20% is already recovered.
That is
No, please understand. 20% of the tax in dispute is already recovered.
That is a fee deposit, but being, my lord,
It is recovered.
as regards the revenue matters, my lord,
So revenue does not suffer that way.
it will be tested before the Supreme Court, my lord, but still.
And the scheme of the other acts are more lenient. In none of the acts, 20% is recoverable. It is only 7.5%. So looking at the scheme, we have to also consider, Supreme Court must be considering, the scheme of the act would be considered at that stage.
It has to be. Because limitation is something very important, as far as GST law or any revenue law is concerned.
Very well. Let us see how it proceeds. Next.
Your Lordship, I appear for the petitioner. This writ is challenging an order from the appellate authority dated September 17, 2024. Our order was rejected as time barred. Now, Your Lordship, on 9th August 2024, we received a demand from the GST authorities for payment of rupees 5 lakhs in odd. What has happened, Your Lordship? The order against which we have received the demand, we were not aware of that. We were not communicated that. Initially, all the...
I communicated, madam, it's on the portal.
Yes, Your Lordship. Initially, all the GST show causes and everything, there was an email notification that used to come for me to check the portal. However, after that, this order was uploaded in the additional notices part, and therefore, Your Lordship, we were not aware. But as soon as we received the email, we filed an appeal. which was rejected as time barred, Your Lordship.
This was uploaded on the additional notices.
Yes, but Your Lordship, I have been instructed that the initial.
When was the order passed?
The order was passed on 1st November 2023.
Oh, then it is pre-designed. This is not the new drop-down box.
Your Lordship, I have.
Old drop-down box also.
No, old drop-down box. We had passed a judgment also. Old drop-down box. Additional notices, if it was there, then the order ought to have been set aside on that.
Then additional notices, my lord, I have to show to your lordship. Demonstrate, my lord.
May I wait?
I sat with my officers. That these additional notices, the portal clearly shows, and at the bottom of the portal, none of the petitioners before your lordship, my lord, is showing the entire portal. But I've sat with my officers, seen the portal. The portal clearly shows that in notices, these items will be reflected. Additional notices, these items will be reflected. Wherein the show cause notice, adjudication order.
No, if the order is uploaded in the additional notices section,
that has been
why will it be uploaded there?
When initially I opened my portal, therein it has been stated that you have to file your replies in this portal and
So it is like this. It is like this. The menu is there. On top, you click on the menu. On notices section, say for a drop-down box comes in.
I come to notice.
Entire drop-down box comes in.
When I click notice, my lord, then and there in the notice there are two portals, but two highlighters. One is notices, other is additional notices. My lord, at the bottom of that page only.
That is under the new redesigned portal.
Even in the old, it was done.
No, the old portal was shown to me.
They never showed the entire page. That has
But that order I am bound to follow.
I was following it, and that has been shown by my officers. But I sat with them. In fact, we all three lawyers, we sat with them around 15 days back. I was shocked that it is there in the portal.
That you did not indicate the court, intimate to the court.
Because I sat with them in their offices. Now, my lord, this entire thing has been so well, my lord, designed
At present, it is different, but this is 2023.
Well designed by GST and my lord.
No, I am not setting aside the order. The original order, I am not setting aside on that ground. But
my lord, can you demand it back?
Yes.
Your Lordship, that was my prayer before Your Lordship to remind.
Yes, I will. Where is APL 4? Where is APL?
Is at page 124. Rejection order is at page 125.
APL 04 is not there.
No, it is there, my lord, at page 94, 95, 96.
No. APL 02 is there. That is the rejection of appeal.
That is 79, 2024 by APL.
But why is your officers not adhering to the directives issued by the court?
They have adhered. They have issued a show cause notice.
And thereafter?
On the reply by the, and considering that reply, they have rejected. Page 125.
Then show me, madam.
Your Lordship.
What is your show cause? What is your consideration? Yes.
Reply was quoted and the RTPS cited reasons for late filing of.
Your Lordship, the show cause notice is at 122 and the order of the appellate court is at 124. Your Lordship, I have instructions that initially the initial show cause notices were being uploaded in the notice orders and notice box. However, right now it is showing under the additional notices and orders box.
Yes, continue.
Sorry.
How many days delay?
Your Lordship, the order was passed on 1st November 2023, and we have filed the appeal on
14th August 2020.
14th August 2024.
Around 8 months.
Yes, you did not send him any email.
I have sent my lord, if your lordship kindly sees. With 125.
Yes.
That he has submitted a reply. That the point of order was not present. Have your lordship saw?
Article reply I read. Your consideration is that since the previous notices he has received on portal, therefore he could not take this defense.
The law 169 prescribes my lord by any.
I've seen that
By
on
any.
16. Any more?
By any.
But is it your case that you also generally provide a reminder by way of a SMS?
These SMSs are very difficult to my lord trace because my lord these are alert SMSs and alert mails.
Which paragraph, madam? Have you put in the pre-deposit?
Yeah, yes,
Yes.
Your Lordship, during the filing.
Yes, I've seen that. You're engaged in the business of sari collections.
The business of sarees, yes.
Challenging the order of rejection of the appeal
May the affidavit of
Let it
service.
remain, let it remain, remain. Let it remain.
Mine is a rough paper.
Okay, okay, okay.
May the affidavit of service be kept on record.
Open affidavit of service filed in court is taken on record. Take it out. Yes, next.
Rough paper.
My lord, 87, I beg to appear on behalf of the petitioner, my lord. And here, my lord, I am challenging an order in original passed under section 73, which is beyond jurisdiction because it has been passed beyond the time as specified under section 73(9). And it has also by relying on the notification number 9/2023 that extended the time limit for issuance of a show cause of the order.
Where is the, what are you challenging? Show cause or the order?
Order.
Where is the order?
My lord, at page 49 it starts.
Yes.
My lord, the relevant DRC 07 your lordship will find at page 57.
49 is the order.
Yes, this is the detailed order. My lord, the relevant
tax period.
My lord, the tax period is July 2017 to March 2018.
So when it's coming to an end?
My lord, it should have come to an end within July 2021 because in accordance with 73(2), the 73(9), the order must have been passed within 3 years, and prior to 3 months, the show cause notice has to be issued under section 73. Now that.
Are you challenging the show cause also? You said no.
No. I was not challenging the show cause.
Only the order.
Yes.
So the show cause was within time. The order is outside the time.
My lord, the show cause notice is within the time by virtue of the notification. Now, my lord, with respect to that notification, your lordship in one matter has passed an order. My lord, in that case also the show cause notice and the order was challenged, and your lordship has been pleased to stay the order. My lord, may I request my learned friend to submit the order in SPR Global.
1718 was extended. This is 1718.
Yes, lordship.
1718 was extended up to 31st December 2023.
Lordship.
In time.
By this notification, the show cause notice could have been issued. But, my lord, my submission is the order is required to be passed, and it has to be passed 3 months.
15 November 2023.
Lordship. Now, this is where the order is beyond jurisdiction. My lord, this is where the order is beyond jurisdiction. Why I say, my lord, will kindly consider section 73.
Are you challenging this on the ground of 168? Say so.
Lordship, yes. 168. Yes.
The CGST authorities are the answering respondent. They have issued the show cause notice already.
You are not.
Adjudication order of CGST, show cause of CGST.
Yes, it is under CGST Act laws.
Mr. Bhattacharya, he cannot appear alone. Oh, Mr. Bhattacharya is there. You are there.
My bench is going in court number 1, my lord.
This matter 87, are you there? Yes, very well.
Kindly takes up tomorrow, my lord.
No, 168, what are you going to do?
168.
Show him the papers.
Yes.
Yes, Mr. Bhattacharya, 168.
Will you not give us direction for filing evidence? These kind of matters pending, my lord. Many matters are pending.
Challenging the order dated 15th November 2023, passed under section 73 of the WBGST/CGST Act 2017. Hereinafter referred to said act in respect of the tax period 2017-2018. The instant writ petition has been filed. Full stop. It is a petitioner's case that ordinarily, in terms of the provisions contained in section 73 within bracket 9 of the said act, the order ought to have been passed within a period of 3 years. However, order ought to have been passed within a period of 3 years. Full stop. In the instant case, however, the same has been passed much beyond the prescribed period, that is on 15th of November 2023. Full stop. According to Mr. Chaudhary, learned advocate appearing in support of the petition, though the respondents have purported to invoke the extended period by relying on the notification dated 31st March 2023 issued under section 168 of the said act. According to him, there was no force majeure condition prevailing. I'll dismiss your matter, Mr. Chaudhary, this one. Why I tell you? I'll indicate no force majeure ground prevailing for permitting such extension. For no force majeure ground prevailing, which could have authorized invocation of section 168. Full stop. I, however, noticed that Mr. Bhattacharya, learned advocate, appears on behalf of the respondents. There was a COVID period, Mr.
No, Lords.
What is
Lords,
your response to the same?
Lordship, it was not COVID period. 11/2023, Lordship.
Yes, so in the interregnum there is a COVID when it was to expire.
My lord,
you want to argue? When it was to expire, Mr. Chaudhary?
My lord, things started regularized from 2021.
Tell me, when it was to expire?
My lord, the which period, Lordship? Lordship is indicating the period to pass the order. My lord, for the period 17-18, lastly they could have availed up to 2023.
That is as per 168.
Yes. That by relying, my lord, will kindly, because there was a fast notification, which is
anyway, you come ready on this.
No.
13 of 2022, which was extended 30th
Mr.
September.
Bhattacharya, learned advocate, appears on behalf of the respondents. So having heard the learned advocates appearing for the respective parties, since the jurisdictional issue has been issued, I am of the view the petition should be heard. First of all, taking note of the fact that the ordinary time period for passing the order under section 73(9) of the said act, further taking into consideration the fact that the order impugned was passed beyond the prescribed period provided for under section 73(9) of the said act, I am of the view that the petitioner, having made out a prima facie case,
They challenge the notification.
I also indicate. I am of the view the petitioner.
Jurisdiction is there, my lord. Jurisdiction is
there. No, jurisdiction. That is a jurisdictional issue.
No, my lord. Main issue here, my lord.
168.
168.
Whether the invocation of the extended period was permissible in law.
Notification sustained, then I have the jurisdiction, my lord.
Naturally. আচ্ছা কি বললাম ওখানটা শেষ কালটা না তার ঠিক আগে under section 73(9) of the said act, and though such period stood extended by the notification dated 31st March 2023 under the provisions of section 168A of the said act, the question still remains for consideration is whether there was any force measure prevailing which could authorize invocation of such extended period. Full stop. Having regard thereto, and since the petitioner has made out a prima facie case, I am of the view that the order impugned should remain stayed. Full stop. Let affidavit in opposition to the instant petition be filed within a period of 6 weeks after the summer break. reply, if any, that to be filed within 4 weeks thereafter.
And affidavit of service.
Affidavit of service. Next.
Grateful, madam.
Next.
But in Navy, they come before this court after 1 year. After 1 year, my lord, they come to this court.
That limitation, is there.
The question
Earlier,
question is
my lord,
11th
earlier
document.
petition was filed, but withdraw some missing of documents.
There's
Lordship
an
was
order.
Granted the liberty to file appeals.
There is an order. না চলুক আর আচ্ছা তো অরিজিনাল সাইট কি করে নেবো আজকে তো এটা আছে your matter is there. Take it up. Yes, call the next one.
Item number 8. Well, a seizure of goods, my lord. The goods were moving to Bangladesh, my lord, for export, my lord. As because the e-way bill was not accompanied, my lord, at the point of interception, my lord, but within a period of, my lord, less than 1 hour, the e-way bill was produced before the authorities, my lord. And the document as regards to the export.
Who is there?
Well, Mr. Siddiqui ought to have been over there, my lord. State, my lord. 129 is state, my lord.
Not here. Next.
My lord, the matter which your lordship took in the morning, my lord, item number 4, my lord. The bill has been, Mr. Sukalposil is having the bill, my lord. Should it be given to the court officer, my lord? The bills, my lord.
Hand over to my
Yes. So that, my lord, lordship can go.
Notification. The comma is not there in this book.
Well, it is. Comma is there, my lord.
Then you will get the benefit. If the comma is there, it makes a lot of difference.
But that is why the circular subsequently was brought into, my lord.
I have
clarifying
to see
that.
whether
My
the
lord,
comma is there or not. Hand it over.
Grateful lordship.
Yes, next.
69.
This matter, I have for the petition deadline.
I'm appearing for the respondent as change brief.
Change brief.
Justice,
Yes,
last
very
name was
well.
there.
Yes, sir. Which is your matter? Call 97 because I will not be taking up any other matters on the appellate side apart from the fixed matter. Yes, call 97.
Yes, my lord. 97, we have challenged the notifications.
Or you want to take it, I'll take it up after the vacation.
My
Who
lord,
is
that-
appearing for the respondent?
Mr. Siddiqui was
168A, these are, and you're challenging,
Yes.
if I'm not mistaken, central, subject to correction.
He's not there. Then after the vacation in July.
July, my lord.
Very well. List this matter in the month list of July.
Grateful, my lord.
Because they are not there. So let them come.
Grateful, my lord.
Because I'm taking it out of turn, I should not. So
Yes, my lord.
call the fixed matter. No, the original side, no, appellate side. No. Yes. Monthly list. July quarter. Only those documents, nothing more.
Let's just, not more than 3 minutes. By the watch.
You see.
Just some very, very technical issues and nothing.
No. I am not permitting you to address. Only Mr. Bhattacharya.
But I'll just.
No.
Okay.
Yes.
The petitioner is seeking the merits of the manufacturers of the.
You want to show me any document? Show me.
Findings itself. Findings.
You wanted to show me documents. What document you want to show me? Hand over. You have not seen that.
No.
Unless you see, unless it is disclosed to your lawyer, I will not going to see it. It cannot be that you will not go through the document, you will give it to me. What are you saying, Mr. Bhattacharya? Please, talk to your client. If you do not go through this, Mr. Sharma, I have never seen such a situation where the client does not have any confidence in the lawyer, then the court is not going to see those documents. No, you take instructions. If they are not willing to show you, I will not go through them. You ought to have checked up these matters. No, this is unacceptable. Mr. Sharma, what do you say as my officer?
As an officer of the court, Malod, even if they have claimed, I have claimed confidentiality.
Yes.
Who are counsel, Malod, they
cannot say unless the council sees tomorrow I make an observation with regard to this. Is it possible?
It is because of that Evidence Act has the provision regarding it.
The council will not see it. You have a protection. What are you saying?
But no, I'm not saying that I don't do as much anti-dumping as my learned friend does. It seems, my lord, in the
Cannot, but it cannot be the council, not the all the councils, but your own council will not see what you said.
Yes, my lord. That is
Certainly,
correct.
certainly, because tomorrow I make certain observations. She will say, I have never known this.
Correct. No. I agree.
It is between the court, like a contempt proceeding. You court and you show me like this, whatever you want to show. You don't need to explain. But you go through the same, not necessary. You hand it over to me, which document you want to show. I'll keep it in seal cover, that I can. But which document, but you go through it. You should know and mark it and hand over.
Just two things and nothing more, my lord. One,
No, these are records he's put. Mr. Mukherjee, records I am entitled to see.
Not the records, my lord. Mr. Sharma making arguments.
No, he'll not argue. No, he'll not argue.
my learned.
I'll let me go. Today is fixed for different issues. Yes.
No.
Thou.
Serial number 1. I am showing.
It's audio side. This is audio side matter. Take it, the audio side matter.
And this is also para number 2, serial number 1.
I mean, which applet side was. Audio side. Para 2, serial 1, I find 19. Just check with him. I find 19 to 20. Then I find 21 and 22. Fair enough. That is it.
And the other one is there. I have given the other one.
Anything else you want to show?
It's para 0.2.
These are referred to in the affidavit. Mr. Dudori, have checked up. Where is the reference? Where is the reference in the affidavit?
Of the affidavit.
Hey, একটা affidavit in opposition টা দাও তো চট করে of the respondent number 1.
Confidentiality. It violates as affidavit in opposition.
So far as this document is concerned, it is para 2.2 of what? Para 2 of the opposition.
We find that the affidavit, my lord, that the place number.
Please understand. Para 2.2 referred to page 19 of this document.
Yes.
Let me test out one, otherwise. Para 2.2. Where is paragraph here? There is no paragraph. These are columns. Hey, what is this? He cannot make submissions. You people get ready in matters. He does not come to an office in a meeting. This is not how you deal with matters like this of importance. He is not in a meeting instructing you in court now.
Your option is submitted page 5. Page 5.
Now listen to me, Mr. Bhattacharya. What this para refers to?
This para refers to the affidavit paragraph.
Paragraph in the affidavit. Very well. Let me find out. Okay. The respondent number 1 in affidavit though. You have a copy? This is not a confidential document. You have a copy? Where is point number 2?
Serial number 2. In the table.
Refer to page 19. Which page 19? Now page 19 of this.
Of the confidential.
Now, wait. Where is annexure 6.1? Where is annexure 6.1? And you have to show me from this document. Because the difficulty is you have not read this document. You have never seen it.
Yes.
Your client should not consider you as a post office.
No, yes. It's just 6.1. This one. This one. 6A. First page. The first page of this document.
This document, the first page, it says pro forma 4 capital A.
Capital A.
4 capital A.
Capital.
Now, where is this for annexure 6A? In your affidavit, a reference has been made. Name of the document is annexure 6.2. Financials of TTPL.
Just after that, my lord.
Where is this annexure?
Yes.
You just can't hand over documents and they say they do not tally. This is pro forma 4A. Where is 6.2? So it's a different one. You want to take back this document? No, naturally, I'll give it back to you.
Yes.
I do not know what is this. Yes.
And now the 6.1.
Para 2 serial 1.
That's in the exhibit B.
Para 2. First of all, this refers to paragraph 4. Paragraph 4, you have mixed up everything.
This one refers to paragraph 5, what the lordship returned to. That one refers to paragraph 4. Yes, your lordship. That one refers to paragraph 4.
So your recording is incorrect. You have recorded paragraph 2 here. Correct it. Correct it. It should be paragraph 2 in this case. Correct it. Correct it and hand it over. দাও এগুলো ফেরত দাও, দেখে দেখে ওদিক, এটা নিলাম, ওটাকে ফেরত দাও, দেখে দেখে ওদিক দাও, ওর কাছে দাও, সব হাতে করে তুলে দিল একেবারে। Now show me which particular document you want to rely on and then hand over. You have only up to now handed over para 2.2. You're not even ready with papers.
Paragraph 5, serial number 3 of the table.
This is para 5, serial 3. No, this is you have indicated.
Your Lordship, it's again a mistake, not on my part, my Lord. It's paragraph 2. Paragraph 2. Paragraph 2, serial 3. Paragraph 2, serial 3.
You write it down properly, para 2, on your own handwriting. On the likhe debe. Yes, so I have got 2 documents. Anything else you want to rely on? Correct it. This is when your client becomes more smart than you. Difficulty is this. He considers himself to be too smart.
Yes. Paragraph 3, contact. Both.
If he does not have confidence in his advocate, he should not appoint. He should argue the matter.
This is paragraph 3, man. What's there?
There is no reference to any e-way bill. Yes, sir. In this invoice. Yes, yes. Yes, Mr. Dudoria, you'll get to know. Where is the reference to the e-way bill? Not there. Very well.
One more.
Yes. Any other document you want to write?
Paragraph 4, point table 1. 1 to 5.
Mr. Dudoria, can a goods be transported without an e-way bill? The invoice has the number of the e-way bill. Yes.
And this is also on paragraph 4, the last item in the table.
Very well. Anything else you want to say? This is all, more or less?
Your Lordship, one more thing I would like to know. He has given me at the first instance.
No, these are all same. These are all invoices, but none of them has an e-way bill reference.
No, the last
Mr. Dudoria, none of them has an e-waybill reference. None.
they don't have. Well, as I am told, we have given, they have verified. And I don't know whether they are producing it.
No, it's on a legal question.
Yes.
I am asking you a legal question.
Yeah.
Mr. Sharma,
Yes, of course.
as of today in India, without an e-waybill, an invoice is not valid.
Otherwise, it will be clandestine removal.
Yes, there is no. So I did not, I'm asking you, so I would have referred to this, circled it. So I did not find one. He would be knowing better because it is his client.
But as far as we are concerned, these are our invoices.
Yeah, no, maybe, but still, then I will not ask you on this.
Yes, of course.
Yes. He has to explain. He has whatever he has received. For this, you need to sit for a conference with the lawyer. Sit down and ascertain what papers you have. Difficulty is you cannot, by this process, maybe certain confidential information is there, but you have to share it with your lawyer. If you can't share it with your lawyer, you also cannot share it with the court.
No, honestly, my lord, they asked me to go to Delhi once. I couldn't.
But matter is not in Delhi. Matter will be here. You will be here. So you ought to have been disclosed these documents.
They came today in the morning.
Have you checked up Mr. Dudoria? This is not there. No, it will be along with the number will be punched in the document itself, in invoice itself, and the e-way will separately will also be there. It's an electronic document. So it's not there. I will take it. No, whatever is not there, he cannot supplant today. No, then you has not appropriately checked his records. And this is something which cannot be generated today, Mr. Dudoria. So,
I understand the problem, but this problem you should have said and
because today, if I proceed on this premise, what do you like to do? You tell me. Sad. Then he did not bring the records he wanted to show. Then I'll take it. Whatever he has been shown to me is there.
Is there, my lord.
You will be in difficulty, Mr. Sharma.
That's the problem. No, I was
No, this is a serious consequence, Mr. Sharma.
Since they cannot produce, my submission is
Whatever is there has been produced.
we are PSUs, public sector.
Please understand, but maybe if you have not produced something, but that is not there attached, so I cannot. He says
Vote on for what is they need a special permission to have that copy. They have a separate team. Separate team.
Team.
There is a verification separate department. Verification. There is a verification team, Malad, which came to our premises, Malad, and verified all of this. So that is a separate team.
Yeah, Mr. Dudoria wants to add anything you want to add? Tell me.
He needs some more time to produce that document. That is the one more last chance for the any day.
Then I will direct you. Then you do not proceed with the levy. I have to stay there.
The reopening date will produce.
This is not fair. You ought to have been very clear.
Since you are
Mr. Dudoria, you tell me, as an advocate, can a invoice be relied on in absence of the e-way bill? Would you consider it as a transaction?
Can't be.
Every day you are moving a matter on this. Every day.
Can't be. So that's why I'm so humble. They have not bring the matter on reopening date.
I'll keep it on the reopening date, but no, not last chance. I don't think anything can be done in this matter now. If it is not there, Mr. Bhattacharya, it is not there. You cannot improve upon that today.
Upon the fact.
Because according to you, all these documents were along with the verification and domestic industry had submitted earlier only. So nothing new is going to come to you today.
Nothing.
If it is not there, it is not there.
According to them, they have a separate team for all that.
And then you ought to have you ought not to have come here. You should ought to have sent that person here. No fun going on here, Mr. Dozoria.
I tender apology.
And in the process, what happens in respect of certain matters where you may have watertight case, you make situation very difficult.
Completely reverse, yes.
Because the consequences you understand. Today, Mr. Bhattacharya learned, আগের অর্ডারটা কি আছে দেখি তো
Kindly allow me to submit one.
আগের অর্ডারটা কি আছে
This also belongs to the paragraph 4.
অর্ডারটা যে কোনো একটা অর্ডার দাও না
This paragraph 4. Chula 443.
নোট করতে হবে
Your Lordship, I submit that we shall not wait for that document.
You give me an index, Mr.
Yes.
You do this
Yes.
because what you have handed over, there should be an index. Otherwise, it becomes difficult for everyone. Because index, they will get to know that these documents you have handed over.
I'm grateful.
Because you see, today at the end of the day, since you are before the court of law, index should be here before this court. You index and supply them what documents you have handed over. The matter had been placed for consideration.
argued the new point.
Yes, but his
so
new
that
point
joint development
on
are-
completion of
Mr.
pleadings,
Sharma,
my
I've
lord.
permitted everyone to argue with the
Completion of
harsh
pleadings, my
content. So
We follow
don't pass that
procedure,
up.
my lord. We cannot.
And Mr. Bhattacharya, you kindly see, you have to, your client cannot come here and make over document directly to the court. You have been appointed.
I am.
You are the counsel. And if your client considers that it could be done in this process, return the documents.
No. Well, the only fact that I wanted to
No,
say
Manoj, I'm
tribunal is
compelled
working
to
on
object.
it,
I'm
and there
compelled
is a
to object,
special
Manoj.
bench that is substituted.
These submissions, my lord, after conclusion of hearing,
So
Manoj,
therefore,
kindly.
the affidavit filed by them, Malad, is false. That is what I wanted to
For
point
that, you
out.
have to file an affidavit and
Malad, that's
Well,
all.
that's great.
If your lordship issues notice, Malad, we will file.
I am not issuing any further notice. I have heard all these.
Malad, but on that note, Malad, may I say this? Malad?
Let's
We have argued
kindly put so
only
quiet.
on the
Only
basis
I'm only disturbed with the fact. I'm only disturbed with the
extensive
fact that the respondent number one could have come a little more prepared. Because after all, having such huge stakes in the matter. Respondent number one ought to have come prepared. Because at the end of the day, and for their conduct, I do not know what will happen. But they have said that this is all they have. They don't have anything.
PSUs, Malad, and these are goods coming in from China. So, Malad, I mean, huge prejudice is being caused to us, Malad, day in and day out. I'm so grateful.
Grateful.
So grateful.
Whatever you had supplied.
I have supplied.
And all documents, and all documents as were well available with the respondents have been disclosed.
Respect to the affidavit.
Yeah, obviously.
Obvious, yes.
And all documents as were available with the respondents have been disclosed.
But I was instructed to submit only 2 points, my lord. If I am allowed, only 2 points.
Yes.
Yes.
You are always subpermitted.
Yes. Number one, they wanted to the names of the producers, Indian producers. All the names are there in the final findings. That is nothing confidential. All the names are there. And number two, they can export from anywhere of the world, save and except China. Only these 2 points has to be considered.
Oh, you want to record this? This is very
No,
interesting.
Yes,
This
because
is one of
names are not confidential. The center related to us.
Very interesting. It says that today this can be imported from anywhere else, save and except China.
Of course. That is a fair market, Manoj. Anywhere in the world, save and except China.
I'll record this.
That is the whole concept of anti-dumping.
Anything else?
But no, names are not confidential, my lord. Names are there in the final findings. Producers of the titanium dioxide. All the names are there.
Grateful. So,
Well, I'm so grateful, Malad. Lordship has been more than patient with this matter.
3 months.
These two may be recorded, Malad. I submitted because
I'll record. These are all live, so you'll get to learn what is there later, whether you had submitted this or not. But I would prefer them not to be live. You see, nowadays it is being misused also. It is being misused.
But it's very helpful for us juniors to keep track on matters where we are supposed to run and where not to run.
You are into serious business very well. That's okay. But people are using it in a different way.
That is, of course, regrettable. Regrettable.
So, Malad, probably a better thing to do as an officer is to do it before the hearing. And you cannot go out of it. Then what happens, Malad, when you are arguing, you confine yourself to a time, and that is what the Supreme Court has now started doing.
Yes,
in a lot of the regular matters.
Yes.
I will be given a fixed amount of time, and I have to finish within that. Like
No,
it is.
I'm on this online.
Online. Oh,
On online.
I'm a huge fan of it. I cannot say.
You see, Mr. Sharma, the difficulty you face is you have made certain submissions in court. Now they can be, I wouldn't say hijacked, they can be manipulated and presented in such a fashion which you did not actually submit. By cutting out clips from your submissions here and there. That is also applicable to the judge also. Same thing. Yes.
I mean, Madhya Pradesh High Court has become viral.
Yes. Sir, no one wants to be there.
But
yes.
There's a disclaimer that usually runs under the live stream.
There, but that disclaimer
The
does
only
not
issue
give
is
you-
at the time of sharing that disclaimer is no longer there. So,
Yeah, that is not there. There is another aspect. You see, there has to be delayed transmission also. Delayed, much delayed. It cannot be live. If it
which
is
is why the development where people can join the live stream but not be added as a panelist is something that is very, very
very
useful.
difficult, today we are accept VC for anyone, everyone. It is, you don't need a special request. It is always there in the list. If you want to join, you can join, and we accept it. So that way it is a good. Technology is helping us. But in another form, it's making a little difficult at times.
I believe there is a committee of the Supreme
Yes,
Court.
yes. Now the Calcutta High Court is also framing rules on this. We are taking into consideration. But I don't want to switch it off. But certainly when content matters are there,
In camera matters, of course.
then we switch it off.
Grateful, Bullets. Grateful.
Daku. Daku. Mr. Mukherjee, I have noted all the arguments. Yes, I have noted all your arguments, so I have not called for anything from you. Yes, everything. Yes, yes. So far as your matter is concerned, Daku. Yes, this cannot be done in this fashion. You have to ask. You are seeking today. What you are seeking by this is incorporation of several new dates. This is not an error. This cannot be done under 152. Section 152 does not permit this.
Let's allow me 1 minute only.
Yes, yes.
My lords have passed a common order for two petitions, 1467 and 145.
So ask for a review of this.
My lord, therefore, my lords, the dates which were there recorded only pertain to one petition, not the second. That is the only error. Had my lords passed separate orders for both the things, separate dates from prayers could have been picked up. The only thing is that from the prayers, only the dates for first petition were picked up, not the second one.
You have to ask for a review of this. I can't help you. Because in this fashion, it cannot be done. This is not a typographical error. Please understand.
Dates have been missed for the two petitions.
Entire set of petitions, the dates are not there. You take out an application, not orally. Initially, I thought it could be done, but later I've seen that. It is not that one date has been missed out, not one, not two. The entire set of the dates from the other petition is not there at all.
My lords, when they pronounced the order that they dictated, my lords, I thought my lord said he passed.
Naturally, you take out. Now I've signed the order. I cannot change it like that. Even I have limitations. I cannot do whatever I want. Court has passed an order, so you have to take out an application.
Application for review.
Whatever you like. I'm not saying. You ought not to have complicated this. At the first instance, I told you.
My lords, I think I simplified it. Had my lords been keeping 50 petitions file after file.
Naturally, so that is the law. You think you can do it in a different fashion?
Lords, I'll file an application.
Yes. You consider how many review petitions you will file.
My lords, review petition only one because now it is only one.
Since the revision, since না না তুমি গালা দিয়ে সিল করো, আমি তো খুলবো ওটাকে। তুমি গালা দিয়ে সিল করবে, আমি খুলবো, বাড়িতে নিয়ে গিয়ে আবার তুমি গালা দিয়ে যখন পরের দিন হবে সিল করে দেবে। রেজিস্ট্রারকে দিলে তো আমি খুলতেই পারবো না।
May I please your lordship? 2 points. One is the main point, lordship, is there in my portal, there are 2 outstanding demands that are being shown, but there is no document
Come
whatsoever.
tomorrow in the morning. I will take up your matter tomorrow.
Lordship then keeps it after the vacations, because
After the
tomorrow I
vacation.
am not there.
After the vacation, দিয়ে দাও। লিখে দাও।
Tomorrow I am grateful. No, no. উঠেই যাবে। I apologize, lordship. I'll come back after the vacations. Yes.
What happens is that way bill contains the invoice details. Invoice has to contain all the details which is required under Rule 46. First, person will generate a invoice in his home. First, he will generate. Thereafter, he will generate way bill. When he will be generating way bill, he will be mentioning invoice number in the e-way bill, and thereafter it will be generated, and he will be liable. Yes. So yes. Correct. Without e-way bill, there is no movement. But my lord's question was whether invoice should incorporate. Invoice will not incorporate other. It is to understand, it has to be yes, it is bad movement, liable to be confiscated.
There is no movement.
There is fake invoicing. Fake invoicing. That's called fake invoicing, and fake invoicing is nowadays, my lord, is something which is troubling my learned friends, clients.
But may I permit to make one submission? But from item. From item number 9 to item number 35. Those are Marlin matters. From item number 10, Marlin same group matters. Item number 10 to 35. I am appearing all those matters. But same assesses will appeal also appearing tomorrow before the Honorable Chief Justice Court. But may I only pray for this? If I not come, we will not make not pass over. I will come. Because after Marlin's there is no matter left before your lordship. Marlin's matter are there. Thereafter nothing is remain in the original side list. Yes, all penalty proceedings, penalty proceedings, section 271D.
The identical matters. But that matter, in those matters, your lordship, I'm being led by.
Yes, I will be. And one matter, 139 is a very important matter, is not that, where I have challenged the vires of the Tea Act and the notifications issued thereunder. Apparently, those are illegal. Those are good point to argue in the court. 39. So I would like to really, I am gearing up to argue with this matter.
Excuse me, I don't have any intimation in change. So I don't have.
Said so, I don't have. I also
asked him, should I pray for time? He said, whatever document we have, that is in the open. Lordship will not record that. Lordship will not record that, my lord. Let it appear. No, I understand. Let it appear in the reopening date, my lord. No, my lord. Let it appear to. Then Lordship will not record that, my lord, subject. Because I don't have a written instruction. He said there's separate department for that. So, my lord, I don't have a written instruction regarding. I'll be in trouble, my lord. It is not available. My lord. I will be in trouble subsequently, my lord. If your lordship. No, I understand. My lord. I understand after this. No. It can't be this. Yes. Yes. That's why, madam, what I'm humbly submitting, let it appear in the reopening date. Yes. Well, Lordship, then upon instruction, because otherwise blame will come to me, because he said he doesn't have, no, he has separate department. So he said I don't have, but can Lordship kindly record there's another, I don't have written instruction from the separative department. So the department who is looking after all that, I don't have written, I don't know anybody from them. Yes.
Are not available. Even supporting even supporting responses are not available.
Yes.
Are not available. So that may be
because otherwise, my lord.
That is why kept it open. But still they haven't been.
Yes.
Must mention. Otherwise, I'll not.
By Friday, my lord.
Otherwise, I'll not accept.
My lord.
Yes, but
I'm grateful.
And what happened to the
as yet, my lord, we have no information. No, as yet there is no. Yes, it is not. Yes. Yes, Krishna. Well, nothing has happened after that. But another judgment of the Supreme Court has come, which is almost on this line, that that we were discussing on the matter whether written statement, if it is being filed and there is no mediation in that, then it can there is no requirement of this. That the Supreme Court has said that even in a suit which is being filed prior to 2022, in that case, even the suit, there is no premeditation done. The suit will continue. There is no harm in that. So, to one extent, that yes, Bombay High Court. Yeah, deeming provision. Yes. That's yes. No, nothing. Yes, that is stands. Yes. Yes. Yeah. Well.